Collective opinion, Jeffrey would have been found not guilty of everything. So this is very painful. But that's another 3 months or so in custody. And he wants to go home to his family. And negotiations totally broke down with the district attorney's office. Horribly broke down. And at that point, we believe that justice would be found with the honorable court. And Jeffrey just wanted to go home. How agonizing it is to know that we've spent a year trying a case where the prosecutors have put on lies, knowing lies, hiding evidence, is insane in 2024 in the United States of America. And the only reason that this got revealed is because of you people. You people brought the truth to the community, because nobody knows this. This is not the only courtroom it's happening in, and I just want to thank all of you. I especially want to thank Jeffrey for letting me represent him. I think he's a wonderful person who does wonderful things and will continue to do things even greater. I cannot express to you how Shaquille Kokomo, how Trisha Renard, how Haley, how my wife Colette, how Bram, how countless people, but especially Miss Courtney Edwards, has worked without sleep for 3 years representing Jeffrey and helping him. I will never...
Yo, what up, fam? How did I miss this? Yo, I must have been snoozing, man. Nah, I caught this part, but I missed the whole thing. I don't know what happened. So I had to start with this. I got a whole 4-hour show. I had to start with this, though. What up, fam? I was going to save. I had a portion set to do my roll call, but let me go and get that started early. Appreciate y'all being here, family. Always lying love. I see you. Paulson, what up? Tony Yardley, what up? OG Cappy, FFS, what up? Laugh always, have fun, what up? Cat Knot Williams with the 20, y'all show Cat some love. She gifted right as I was activating it, so her picture didn't pop up. But let me see, I can do this real quick. Boom, there's her picture. But yeah, appreciate it. Y'all show her some love. Drop some slime brothers in the chat for Cat. In the chat for Cat. Appreciate y'all, family. Show us some love. 24 Key, what up? Adrian Sims, what up? Philip Cantolin, what up? Kate, what up? Shauna, what up? Whoa, it's a lot of names up in here. Oh, those is from the gifted memberships. OG Cappy. All right, we're going to get into it. Appreciate y'all, family, all being in here. Nurse Fancy, what up? I see you. Flocker, what up? Kenya Savage, what up? Appreciate y'all, family. We're going to get into a little bit of this before we get the show I had prepared, because I missed this. But we got to talk about it.
Be able to stand with anyone more ethical, honest, hardworking, insightful, intelligent, and kind than the Honorable Keith Adams. The gentleman to my left is the best lawyer in the country.
Mr. Steele, do you think prosecutors negotiated in good faith at all during any of these negotiations?
Let me take this one. Let me answer that. The short answer is no. This is a case
Daniel Berry, what up?
that possibly could have been resolved if folks were reasonable. But we did not believe that we could enter into good faith negotiations with people who wanted a case resolved in a manner simply to save face. And Jeffrey Williams was not going to say things that they wrote for him, that they wanted him to say, that was their theory when it wasn't true. And so, good faith, no. I don't believe we were ever really negotiating in good faith. And you've been here the past year that this case has been on trial. You've seen the numerous motions for mistrial. You've seen the behavior of the state. You've seen the dishonesty. You've seen everything being hidden. You've seen things come out in court, in front of you. And
Texas T, what up, family? Appreciate you joining. Stephanie, what up? Y'all see this today? Free Thugger, huh? Free Thugger, let's go. He coming home. It's some bull, but at least he coming home.
And so you know what kind of prosecution we were dealing with, and that's okay. You know, Mr. Steele and I have fought through this the past 2.5 years. And as he said, we ultimately decided we were going to put our faith in the court. as opposed to the folks on the other side of the aisle. And, you know, the best thing out of all of this is that Jeffrey Williams, in a very short period of time, will be home. And that's all we've wanted from bail without a bond for the past 2.5 years. He'll be home shortly.
Keith and Brian, this is either one of you can answer. I have 2 questions for you. First off, you go into a blind plea, you don't know, right? There's nothing for sure. What was your emotions like when you guys went into that? I would imagine you kind of take us into the room before you went out into court, what the conversations were back and forth. Obviously, I know there's attorney-client privilege, but it's a big decision.
Well, I didn't want to give up the jury trial, but that was a decision made, and once that decision was made, we were just thankful that there are people like the Honorable Judge Whitaker who understands what a trial is like and what it should be like. And I cannot thank the Honorable Court for being here and coming in. She is not our first judge, but she's the first time we received justice.
Mr. Adams, this is your second high-profile RICO case here in Fulton County. Do you think that maybe the prosecutor's office is abusing that statute? And what are your opinions of RICO generally?
I have, for the 30-some-odd years that I practiced law, always believed that if you, as a prosecutor, think that someone has committed a crime, you charge them with the crime, you put it in front of a jury, and then you do it fairly and let the chips fall where they may. The courtroom is not the place to get adventurous, to get inventive, to think, well, we don't have evidence on him for any of these incidents, but maybe, if just maybe, we tie him up in a RICO and put him with people who may have committed crimes, we can get him that way. That's an abuse. And so, yes, for some strange reason, the Fulton County DA's office...
Lady L, what up? B Hall, I see you, family. What up, what up, what up? Congratulations, Thug. YSL Tara, what up, what up? I see you. Lee B, what up, family? Appreciate you. Who that? Miss Bennett, what up, Mrs. Bennett? I see you, family. Appreciate you. Wilma, I see you. T.I. Ty GQ, what up?
Office seems to be in love with RICO, and my honest opinion is that they're in love with it because it makes it easier for them to try and convict people that they otherwise could not convict. And that's what was happening here. We're fighting a mountain, reams of evidence, most of which didn't have anything to do with us. And so, is it an abuse? I think it is. There are better ways to, and I used to be a prosecutor, right? And I can tell you that there are better ways to prosecute cases than the way this case was prosecuted.
You guys obviously rejected initially what the state was going to offer. Is there some details you can give us? Because it sounds like from what you guys decided in court, I mean, it's still pretty stringent. There's a lot of different details, but what was the state asking for that you guys rejected?
I'm not going to get into plea negotiations because they are privileged under statute, but it was outrageous. They would let him out of custody, but they would have a tether around him so tight that it's unconscionable.
And how are y'all feeling about what the sentencing is, especially with not being able to be in Metro Atlanta except for specific parameters, and how is Mr. Williams feeling about that decision?
What up, Stephanie? I see you. Welcome to the family. Appreciate you joining. What up, Pure Art? I see you.
There comes a time in any case, if a person is sentenced, that we're out of the courtroom, and now what happens to that person is entirely up to them. Jeffrey Williams is a fantastically talented man. He is a great person. He's become a great friend over the course of the last couple of years.
Free Yak, free SB. That's a fact. Free Yak and SB. Shout out to Nurse Fancy.
And he has the ability, the incentive to go forth and do everything he needs to do to put this behind him. And we're confident that he will. One of the questions you asked a little earlier was, what was that feeling like, stepping into a courtroom to do what's called a blind plea, not knowing what's going to happen? You know, it's a scary feeling for all involved. There's probably no feeling quite like that other than sitting in a courtroom waiting for a jury to come out and tell you what your fate is. But we walked in there knowing that we were in front of a fair tribunal and being comfortable that the right thing was going to happen, and the right thing did.
What do you think about your client just serving as a role model? Obviously, as part of the agreement, he's going to be participating in the community, doing events, things like that. Obviously, he has a huge reach for what he does for a living.
I've known Jeffrey Williams. I've defended him for over a decade. I have been with him where we go to young children, children in need, children who are going down the wrong way. And he tells exactly what he's going to continue to say. He tells everybody, this is not a good life. We have to stop the generational disaster that is plaguing the community. And although right now I'm successful, I'm a product, but every one of you can get out. And he always stresses education. Jeffrey Williams is a great person, great role model, and he will do even better now, hopefully, if you allow him and his words to get out. As far as how Jeffrey's feeling now, he knows my feelings, which I'm not going to reveal for attorney-client privilege, but this is not the same as a not guilty verdict. That should have been rang. But nobody here wakes up every day on a concrete floor that they're calling his bed, gets up at 4:15, gets shackled on his feet, his waist, and his hands, comes to the Fulton County Courthouse to be on concrete, eating out of a bag. Doritos is his meal of choice. And then coming to a courtroom and sit there with a leg chain on him every single day and hear lie after lie. So for Jeffrey to go home today and not have another 90 days or 120 days of it, he is very happy, thankful to the Honorable Court. So to answer your question, this was not what I wanted. I don't believe that it is just, but I believe that under these circumstances, it is justice for Jeffrey Williams, and he is delighted, as are we. I'm thankful.
Can I ask you, you were standing right next to him as he was addressing the judge. What seemed like a very sincere apology to her, or apology to the court, and what happened, what has gone on. How did you feel sitting?
What up, Chad Diggy in the house. Y'all said the sound messed up. I tried to cut it up. Let me know, is it choppy? Is it just my voice, or is it the video and the audio? I mean, is it just the video, or is it the video and my voice?
Next to knowing him for the last decade as an attorney for him, about what he was saying and what he was telling the judge.
Jeffrey Williams is being truthful. That is his heartfelt feelings. He feels so bad for the loss of life, and he feels bad that people are taking his music or his social postings and making it into violence. That is all promotion. That is not a symbol of go hurt somebody. So I hope I've answered your question directly, but how I felt, I've heard that from Jeffrey over and over again.
You called out a lot of challenges in this trial.
Puerto Rican Gloria, what up, family? What up, cousin? I see you, Joanna. Appreciate y'all joining. Cynthia Torp, Three Faces in the Hood, Chloe Albert's Revenge. What up, family? Appreciate y'all joining. Let's get it.
Based on the prosecution's point, do you have any message to, the co-counsel that for now is still on trial, or what's left of this?
Oh my God, they are phenomenal lawyers, and I'm confident if you keep going, which I assume you will see some great lawyering. They don't need my help.
And the truth is, they've been there with us for the past 2.5 years. They're aware of what they're up against. They are totally capable of handling it, and I presume we'll step in from time to time because, in this fight in the past 2.5 years, we've been together. So we needed something, they've been there to assist, and if they need something, we're happy to step right back in and assist. But they're great lawyers. Max Shard, Doug Weinstein, those gentlemen are in great hands. They'll be fine.
I will say this, I think it is wrong.
Thank you, ADL. Yep, we hit that 3K, even with the haters hating. It's all good. Nah. What up, Brandy P? I see you. What up, Lady L? Appreciate y'all joining.
And it needs to be fixed that an innocent man is arrested on May 9th of 2022, is denied bond, and has to plead guilty and NOLO to get
it's the after party, family. We about to get into it tonight.
Freedom after 2.5 years in custody. That should not happen. Nobody should be on trial. Jurors, think about what they're going through. Nobody should be on trial like this. And if Mr. Williams didn't have the resources, this never happens well for anybody. So I think it's an abuse.
Hey, yo, Crime Tonic Limitless. What up, family? Appreciate you joining.
To answer the AJC's question, I think it's an abuse of the statute of RICO to do this to people.
Is it fair to say you don't believe justice was served today?
I believe that Mr. Williams is home, and I'm delighted. Justice would have been served on May 8th of 2022 if the grand jury no-billed his indictment. That would have been just. And it's wrong to be under investigation. He's been under investigation for 15 years. 15 years by task force of federal government and local government. Think about that. Think about your children doing that. And that's okay. If it's okay with you all, then we should really start moving to another country. I want to thank everybody so much for everything you do. I cannot thank you all, because without you guys, this just keeps rolling in injustice. It's got to end. The criminal justice system, the presumption of innocence, the Brady rules, the ethical rules, they have to survive. Otherwise, we all are victims of this. Anyone can sit in that seat next to Keith Adams. Thank you all so much.
And no one sees it unless you guys do what you do. But I tell you what, there is a whole world of people out there who have watched this trial over the course of the past 2.5 years. The past year that we've actually been in the courtroom trying the case, who are much more educated to how things work, and unfortunately, sometimes how things don't work. Thank you, guys.
Thank you, everybody.
Thank you.
All right, fam. I had to throw that in before I got my actual show started, cause man, I honestly wasn't expecting that. Appreciate y'all joining, family. Hit the like, hit the subscribe, tap in, share with a friend. Now we gonna get back into our regularly scheduled programming. Appreciate you all, family. Peace to all the gods and goddesses. Back again with the vibes of the divine. I am the god Shango, and today, get ready to take another deep dive into this electrifying world of the Young Thug Rico trial. Let's get into it, family. New track out now. Y'all go sub up to Reggie Righteous. I'm gonna drop the link in the description. Actually, it is in my description. I'm gonna drop it in the chat. Y'all go sub up.
You don't have to catch a body if you don't have to. Can't find solace with your past passing you.
He is now headed to prison for nearly 10 years.
Gatekeeper. Madam, you can call your first witness if you'd like.
In a break from the months-long jury selection process, lawyers for the Fulton County District Attorney's Office made the case to put Quantavious Greer, known by his stage name as YOUNGTHUG, back behind bars.
Where was it that the defendant indicated he would be residing?
Prosecutors today calling on several undercover Atlanta police officers to testify, which is why we are not showing their faces.
On May 4th, 2023, were you working in an assistance capacity with the Apex unit on or near 221 Cleveland Avenue?
Yes, ma'am.
Greer was arrested on May 4th. He's charged with unlawful possession of a firearm and unlawful person employed by or associated with a criminal street gang. Both charges are a violation of his plea deal from December related to the RICO case brought by Fulton County DA Fonnie Willis.
Did you ask the defendant to step out of the vehicle?
Yes, ma'am.
Today, multiple officers took the stand, answering questions and reviewing camera footage. One describing the night Greer was taken into custody.
Was there anything that caused you an immediate concern once you opened the door of that vehicle?
There was a firearm that was in the door panel.
The officer stated when he encountered Greer with two other officers, Greer was driving a Mercedes G-Wagon, and that when he asked Greer to roll down the window, he smelled marijuana. He also testified he saw the handle of a Glock in the car door panel.
Once I opened the door, he stated pretty much an utterance that the firearm was registered.
Greer's attorney asked for leniency and for the judge to consider Greer's lack of prior felony conviction, but ultimately decided to revoke the remaining 9 years of his probation. The judge today said the plea deal Greer accepted in December was straightforward, ordering him to serve 10 years probation, and he couldn't possess a gun. But within 6 months, he broke that rule, and that is why the judge today revoked his probation and is sending him to prison to serve the remaining 9.5 years of his sentence behind bars.
What up, Berta? I see you, family. Cynthia Torp. Casey J, I see you. We just getting into it. Do a little roll call. We're going to see a little bit of all the people that was involved. Like you see right now, how many people was in that courtroom. It was a whole bunch of people at the beginning. It swindled down. Appreciate y'all being here, family. Hit the like, hit the subscribe, tap in, share with a friend. Look at all them people that was in there, man. That's crazy. 28 defendants. How?
If I would ask that if you don't have any other reason, please wear a mask. We have a high positivity rate for COVID, RSV, strep throat. Just a lot of nasty bugs going around. So if you could, I still have issued the order on this side of the
What up, no one? I see you, family. Appreciate you joining.
Courthouse for masks. So unless you're talking, if you could please go ahead and wear a mask, that would be great.
going on with the faces? Why they not popping up? Appreciate you, Berta. Y'all drop some slime brothers. Show some love to Berta S. Appreciate you, family. I just wanted to get some early shots of how everybody was looking a long time ago, because some of them are gonna be popping up in the news clips from today that I'm gonna be showing. But I just want to get a clip of all of them in the same courtroom. That's crazy. Drop them slime brothers for Berta. We appreciate you, family. Y'all hit the like, hit the subscribe, tap in. We about to get into it. If y'all want to, let me see, I'm going to pull up a poll. If y'all want to go to some of the Thug hearing from today, I'm kind of excited.
All right.
So we could jump to some of that if y'all want and come back to this. Let me see. I'm going to pull a poll up. Appreciate y'all, family.
Damone Blaylock. Sorry.
He's here. He's talking about something.
Where's Mr. Hill? All right, Mr. Williams, Mr. Steele, Mr. Adams, good morning, gentlemen, or good afternoon. All right, Mr. Jimenez and Mr. Dorsey, good morning, or good afternoon. Mr. Johnson and Mr. Eppinger, good afternoon. Mr. Farley and Mr. Menendez, good afternoon. Mr. Matthews and Mr. Huey, good afternoon. All right, Miss Hingerty and Mr. Weinstein and Mr. Kendrick, good afternoon, councils. All right. Ms. Fagan and Mr. Mender, good afternoon. Mr. Myrick and Ms. Bernard, good afternoon. Okay, Mr. Harvey, good afternoon, and Mr. Nichols, he was with us just a little bit earlier. Mr. Harvey, I understand that your client is still laboring under a little bit of the COVID issues that we have, unfortunately, still going around as a public health concern. We have had, in the interest of full disclosure, several bench conferences with the state to discuss the issue of your client's presence. It is my understanding he does not wish to waive his physical presence for anything substantive, which would include hardships, but he is willing to go forward, or he's willing to have you waive his presence for the limited purpose of having the jury fill out the questionnaires for this afternoon. Is that correct?
That is correct.
All right, sir.
Lady Justice is blind. Everybody can get it.
Okay, all right. And Mr. Williams, good afternoon, councils. All right, Mr. Stillwell, Mr. Botson, Mr. Sharp, good afternoon, gentlemen. Okay, all right, wonderful. I'm sorry, I didn't hear you, sir. I'm sorry.
They have us as Jackson instead of Stillwell.
Okay, maybe we can have that corrected before tomorrow morning, okay? Okay, all right. Okay, so everyone's here that's supposed to be here. Councils, what I'm going to do at this point in time, given the fact that we have spent the morning just taking care of administrative, getting the juror video loaded up. So what about when I start playing the tape? Are you going to absent yourself at that point in time? Yes, because I mean I could give you that particular and I'll have to think about it, Mr. Steele, because we do have other, you know, I know you have a Sixth Amendment right, but I may make a decision otherwise. So
I will stand on my objection. If you allow me to come, I'll put it on record. If you allow me to come, otherwise, you can say.
yeah, I mean, if you want to come, that would be fine. The issue for Mr. Williams is there's, is the protocol of transportation around the courthouse. And if I allow him to do that, I've got to let everyone else do that. It's in here, and I'm not set up to do that.
Mr. Williams would like to be present with us. I understand what you're saying.
Okay, and I'm telling you that you will be able to see, and this is just for the purposes of getting our jurors situated. I'm not going to examine them for hardship or otherwise, not here. So we'll do that down in this courtroom 1C, but there's just not, physically enough of a space issue. So I understand what you're saying.
We'll stand on our position and objection. Thank you.
I know that we don't hear Mr. Harvey's prior joining the objection, but one thing.
Okay.
All right, ladies and gentlemen, can you all hear me? Okay, your day started out something like this. You came here from wherever you live in our great county based on a notice that was probably on your nightstand, your refrigerator, or your junk drawer, or some other place you keep stuff in your house. You took one of means of conveyance to include being dropped off this morning, and then you came here at dark 30, and you came up here to the 7th floor, and you've been sitting around for the day. Is that your kind of experience? All right, I got a notice on my fridge. I'm coming up here to do that on the 12th. So everybody gets called for jury service at some point in time. But jury service, I would submit to you, ladies and gentlemen, is one of the most important things that we do as a citizenry. And the U.S. flag that's behind me is the biggest representation of our responsibility to serve as jurors. There are young men and women who come from every hue and cry, every religious background, who are in all the four corners of the world, ready to give the last full measure, so each one of us can feel irritated and have an opinion. So I would just ask that you respectfully kind of keep that in mind, or in conjunction with what I'm going to tell you over the next several minutes, okay? This is not a perfect process. If it were perfect, you would have come up here and we would have got started at 9:01. But there's a lot of things that happen behind the scenes of justice that aren't explainable at the time that we're going through them. But rest assured, they're to ensure that each person under our U.S. and Georgia Constitution enjoys a fair trial, a lawful trial, and a just trial. So many of those things happened this morning before you got here, and it just took a little bit longer than what we expected. So you're probably asking yourselves, well, what's going to happen now? We've been here all day long. I'm going to tell you. What's going to happen in just a...
Hey, Greg Page, what up, fam? I see you. Appreciate you joining. We just getting a little bit of this jury instruction real quick. That's crazy, all this time they spent on this case. And now they ain't need it. Well, we don't know. We still got Shannon and Yak. What up, Felisa? I see you. Appreciate you, family. Miss 2 T's in the house. What up, family? Appreciate y'all joining. YP Com Chick, what up, fam? Appreciate you. I see you.
In a few minutes is you're going to watch a video that has the instructions for this particular trial that you've been summoned for, as well as the indictment. It's a reading of the indictment. Now, before you all take that apoplectic breath, I'm going to tell you that the total length of time is going to be about 3 hours, 45 minutes. It's like Avatar, but, hopefully you like that. But in all seriousness, it is going to last about 3 hours and 45 minutes, and we're going to break probably about every hour and 15 minutes and go ahead and let you all take comfort, and then we'll show the rest. Once that is complete, so it's 3 separate sittings of that particular juror video, you will then be asked to fill out a questionnaire. The questionnaire, once you complete that, then you're done for the day. Only those of you that wish to be examined for hardship, I'll ask you to come back on the 9th of January to courtroom 1C in this courthouse, if and only if you want to be examined for hardship. So, the letter that Ms. Von Keltz and her team gave you this morning kind of has some information on it about your juror number. Okay, right, okay. You're going to get one, okay? All right, okay. All right, Amy, don't do that to me. All right. So you're going to get a letter, and your letter will correspond with a number. And then you'll need to call the particular number on this letter, and it will tell you when you need to report. Now, the only people that definitely need to report on Monday the 9th will be those people that want to be examined for hardship. If you don't want to be examined for hardship, then you'll use this letter, and at some point in time, every night Ms. Bonkels and her team are going to tell you, you need to call after 5 o'clock and check the recorded message line to see whether or not your particular number or group needs to come in. Okay? So that's what's going to happen short term and long term. Now, I know with every group, because I was probably one of them, that kind of thinks this. Well, you know what? My fund meter's pegged, Judge. I'm not coming back on Monday. You can't make me come back. What are you going to do? Well, unfortunately, if you don't come back on Monday, I will send these nice gentlemen who are wearing these gray and black uniforms to come visit you, either at your home or your office, and they will force you to come back, and we'll have a very uncomfortable conversation. Let's not make that.
Lady Justice is blind. Everybody can
If you want to be examined for hardship, please come back on Monday at 8:30, courtroom 1C, and I and the lawyers will go ahead and hear your concerns as to why it is that you may or may not be able to serve as a juror. Now, you probably ask me, well, can I do that today? Judge, I don't care what time of day it is. I want to be examined for hardship today. I unfortunately can't do that. This space has been rented out for a wedding at 7 o'clock, so I got to get out of here, okay? No, I'm serious. By the time you all finish the video and we finish you filling out the questionnaires, we're done for the day. I've sucked up as much of your time as I possibly can do for today, and I really appreciate your patience on behalf of Amy Bonkels and her team in jury services, as well as our advocates, who you'll get a chance to probably talk with a little bit later on. Okay, so just to recap the most important points. You're going to see a video. It's going to start pretty soon. We're going to go about an hour and 15 minutes. We're going to stop. You're going to take comfort. For those of you who want to take comfort, we're going to.
What up, Anthony Mullins? I see you. Dang, I said muffins last time. My bad. I could see the L's now. I had it on the small screen. I got it on the bigger one. My bad about that. Appreciate you joining, family. I thought Steele requested 3 years to serve on probation. To report probation.
Do that 2 more times. Once that's complete, you're going to fill out a questionnaire. Once you're finished filling out the questionnaire and you get your letter, which gives you the instructions that I just mentioned, you'll be free to go. If you wish to be examined for hardship, you'll need to come back on Monday, January the 9th, courtroom 1C. You'll not come back up here. You'll come directly to 1C, and then we'll examine you for hardship. Okay? So, with that, ladies and gentlemen, I hope by way of explanation, I know that doesn't alleviate what you've gone through today, but we really appreciate your patience, because without you, we could not conduct business in the criminal and civil justice system.
YSL case, really an update, because we've told you in the past that several court-appointed defense attorneys, they felt so grossly underpaid, they actually wanted off the case.
Our Joy Lim Nakrin learned now they are about to get some kind of a raise, right, Joy?
That's right, Alan. Comes after a long, hard fight. So the trial is now in its 5th month. A jury has still not been selected, and these court-appointed attorneys who were getting a flat rate of $15,000 for the entire trial said they couldn't afford to stay on since the trial was projected to last well over a year. In fact, one attorney on the case told the court and the public that she would make more money working at Chick-fil-A, and she submitted a motion to withdraw from the case, citing the egregiously low wages. Well, today, attorneys on this case learned from the Georgia Public Defender Council they will now get a monthly increase with a pay cap of $55,000. But it's a rate that defense attorneys I spoke to today say makes it sustainable to actually defend their clients. Of course, this case has been filled with a lot of twists and turns, including an attorney being arrested just weeks ago. And with 28 defendants charged and more than 300 witnesses, undoubtedly much more ahead.
And the shenanigans.
Yeah, and to be clear,
by 1 point. So we're going to keep it rolling, family. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend.
this defendant is not a part of that main trial that we're seeing unfold with YOUNGTHUG. His case was actually separated from that trial. Meanwhile, Nicole Fagan was released earlier today here at Fulton County Jail on a $40,000 bond. But we spoke with an attorney who is close to this case, and he says the charges should not stick. Nicole Fagan has been representing Tinquarius Mender in the ongoing YSL RICO saga. Mender's case was separated from rapper Young Thug's massive RICO trial, but now Fagan is facing gang-related charges of her own.
It just goes to show that they want to throw a gang count at anything.
This all stemming from a deadly shooting back in 2022, where Atlanta police say Fagan called one of the suspects in that shooting and told him police were coming to arrest him and he needed to get rid of his phone. Police say Fagan was not representing the suspect at the time, but now she's charged with participation in criminal street gang activity and solicitation to tamper with evidence.
That does not amount to criminal street gang activity. What kind of ridiculous charge is that?
Serene de Chada Jimenez has worked on the YSL case. He says if this is proven to be true, the most she should get is an ethical violation.
Maybe I'm absolutely wrong, and they have clear evidence that she is a gangbanger. She has been a member of this criminal street gang. She posts pictures and signs and uses the words. I highly doubt you're going to find any of that evidence.
Who need public attorneys.
This case is slated to last for about a year, and if you were to do the math, it would be $6 an hour. I can't take any new cases. I can't close any cases. I need something to survive off of.
Criminal defense attorney Angela D. Williams calling out the Georgia Public Defender Council, which is the state agency that appointed her to represent one of the defendants charged in the Young Slime Life gang case against rapper Young Thug and his alleged associates.
But we were under the impression that GPDC was advocating for us, and once they put those walls up, I'm thinking maybe I need to start an OnlyFans?
D. Williams says she came to court today hoping to question GPDC's executive director, Amatayo Ali.
I asked for additional funds back in March, and that was met with a letter from the director saying she doesn't need to meet with me anymore.
But the executive director never took the stand. Instead, one of her lawyers stepped in for her.
I'll just stand on my motion as far as my argument to hear what Ms. Ali could possibly have to offer the court that couldn't be available through me or someone else.
Okay, let me take a few minutes out and let me let you talk with Ms. Glazier.
After a 10-minute closed-door meeting between D. Williams and GPDC, the two parties agreed they would meet again within the next 2 weeks. While a spokesperson for GPDC says they're working to find additional funds for lawyers who are currently getting paid $15,000 for this entire case.
If they really cared about those who are indigent, they would use the taxpayers' money wisely.
An attorney wanted out of a trial, which she says keeps her from earning a livable wage. Atlanta News First Rachel Aragon was in the courtroom. So, Rachel, after today's hearing, the defense attorney is now staying on the case.
Yeah, Angela D. Williams will stay on this case and continue to represent her client, which is one of the co-defendants on trial. But her attorney pointed out, unlike the other co-defendants, including Young Thug on trial, they have multiple attorneys. But again, as her attorney pointed out, it's just her taking on this workload.
In your opinion, is that enough money?
Angela D. Williams filed a motion to withdraw from the case, citing financial hardship from the length and commitment this trial requires, which she says prevents her from taking on new clients. D. Williams is contracted with the Georgia Public Defender Council.
The first contract she signed, she came back and said it was not enough. We modified it and increased it tremendously to the tune of $55,000 a year.
Last year, the attorneys on this case that are contracted with the Defender Council learned that they would get a monthly increase with a cap of $55,000.
I can't take any new cases. I can't close any cases. I need something to survive off of. And I also need funding for Mr. Ryan.
For a trial slated to continue well into 2025, according to the motion, D. Williams' attorney making the case that $55,000 a year isn't sustainable.
What about paying her a fair hourly rate for her representation?
We had a contract. If she's no longer able to do the contract, we will respect the judge's decision.
Okay.
The judge ultimately denied D. Williams' motion to withdraw from the case after her attorney and the Georgia Public Defender Council agreed to D. Williams now getting $5,000 a month through the duration of this trial.
If you all have come to an agreement, then I will.
I'm not sure, but I got the clip. We can play it a little later. Appreciate y'all, family. Let's go.
Certainly, at this point in time, I'll deny the motion to withdraw, okay?
Thank you, Your Honor.
Okay.
A few months after getting out, he was in Atlanta, rolling with Lucci and shooting at their enemies in December 2020. Lucci, CP3, Liddy, and James Adams went on a mission to hit their rivals. Adams was recording the whole thing on his phone, not knowing it would be his last day alive. When they spotted some guys on the street, CP3 and Adams started shooting from the car. hitting one of them in the stomach, but the other guys fired back, hitting Adams in the head. Lucci, who was driving, sped off when the shots were returned. Instead of taking Adams to the hospital, though, they pushed him out of the car and left him to die in the street. A passerby found Adams bleeding out and called 911, but it was too late. He was pronounced dead at the hospital. It's not clear how the cops tracked Lucci and the others down so fast, but by January 2021, warrants were out for their arrest, and Lucci turned himself in. Rumor has it Adams had been recording everything before he got shot, so if the cops found his phone, they probably had all the evidence they needed. After a couple of years fighting the case, Lucci, CP3, and Liddy all took plea deals instead of going to trial, which could CP3 got 25 years, Liddy got 15, and Lucci got 10 years in prison, with another 10 on probation. But jail in Atlanta was rough for them, especially CP3, who almost got killed in August 2023 when a video surfaced showing him getting jumped and stabbed by guys allegedly linked to YSL. Luckily, CP3 survived, but he wasn't the only one who almost didn't make it. After Lucci got locked up, someone tried to shank him in prison, and he claimed there was a hit out on him. Reports say that 2 YSL affiliates, Big Briss and Antonio Sumlin, allegedly asked Young Thug for the green light to take out Lucci, with another YSL member named J-Man supposedly being the one who stabbed him. Here's what we know about the prison situation. YFN Lucci claimed he was stabbed on February 9, 2022, while incarcerated at Fulton.
Hey, FFS, I said that because that's what Glanville asked Woody. He said, "What's your pleasure?" when he was asking him, do he want to testify?
County Jail in Atlanta. Lucci alleged he was attacked from behind while on a video call with someone outside the jail. He claimed the attacker used a homemade shank. An incident report obtained by credible sources confirms that Lucci was involved in a fight on February 9, 2022, where he and another inmate had sharp objects in their hands. Lucci suffered a laceration to the head during the altercation. Both Lucci and the other inmate received medical treatment and were cleared.
All right, well, YFN Lucci is asking to be released on bail and placed on house arrest because he was attacked. He was attacked on February 9th and stabbed by an inmate who used a homemade shank. He said he was told there is a price out on his head and he should be granted that bond because he could die right now if he's in jail. So if his request is granted, he's willing to agree to 24-hour home confinement and also to wearing a monitoring device. He was previously out on bond for the murder trial he's suspected of driving a getaway vehicle for, but he was taken in after violating the bond's conditions by going to the studio and the strip club. So I think if...
Find Fox 5's Deidre Dukes live with the newest developments. Deidre.
Yeah, and 2 men are behind bars, the Atlanta police, for a murder that was committed earlier this week. A motorist was shot and killed. A third arrest was tied to a murder from last year. Homicide detectives making it clear today that they are going to solve these cases, put those suspects behind bars, no matter how long it takes to solve these crimes.
What up, Crazy Chris? Appreciate you joining. Glanville be looking at her OnlyFans all the time. What you talking about?
18-year-old Fernando Felton now behind bars in the Fulton County Jail, charged with murder in the shooting death of Jakari Dillard. The teen was an innocent bystander who was shot and killed at an Atlanta City pool last year. Police say Felton's family and friends helped him elude police for months' criminal street gang.
As our chief and our mayors indicated, gang activity will not be tolerated in our city. Violent crimes will not be tolerated in our city. This incident occurred on March 14th, and you already see where the chips have fallen.
And police are asking for the public's help as the search continues for suspects in the murder of 16-year-old Joshua Adetunji. He was shot and killed March 5th. The teen and his friends were attending the fair in Southwest Atlanta. Officers say 2 groups of teens got into a fistfight down the street and someone pulled out a gun and started firing. Adetunji was shot through the heart. 2 other victims, a 19-year-old male and a 14-year-old juvenile, received non-life-threatening injuries. Police say Adetunji was not the intended target.
And this was an intricate investigation. This was a difficult investigation in the fact that there were several persons that were involved in this incident on the night in which it occurred.
And police are asking for anyone with information in connection to that fair shooting.
An extremely talented investigator that has worked truly relentlessly on this case. Without sleep, several days into the investigation, he was working to identify all parties involved. And this was an intricate investigation. This was a difficult investigation in the fact that there were several persons that were involved in this incident on the night in which it occurred and working to identify all the parties and moving parts regarding that investigation. What we do ask at this time is that the public, despite the progress that this investigation has made, we ask that the public continue to provide our office with information. If you heard anything on that night, if you observed anything on the night of this incident, we ask that you come forward and continue to aid us in building upon the investigation and where Detective Malone has brought the homicide unit in this office to this point at this time.
Bees on Mars, what up, family? I see you. Appreciate you joining.
So we'll probably answer some additional questions regarding that incident after the recap, but we are happy with the progress that is made there and the substantial work that's been done. And then finally, or the final two incidents, the Windsor Street and I-20 incident, we've garnered a lot of questions in relationship to that incident. This was on the evening of March 14th.
Jerome Street, what up, family? They about to talk about Yak Gotti and Shannon when they got arrested. Appreciate y'all joining, family. Appreciate the love. Hit the like button. Show us some love.
In which there was an individual seated at a traffic light and vehicles pulled up adjacent to that vehicle and fired a barrage of gunfire into the decedent's vehicle. He was pronounced dead on scene, and once again the Atlanta Police Department's homicide unit began to work relentlessly through the night to move that investigation forward. And we were working in tandem with internal partners in the Atlanta Police Department as well as external partners, including the Fulton County District Attorney's Office.
That's a fact. Lil Rod was 11 years old when they started the 2015. Back in 2015, he was 11 when they started all
We were
this.
able to identify the persons responsible for that act, and those persons are Shannon Jackson, 5'4", of 1992, and Quamarius, we'll provide this information to your office as well, Quamarius Nichols, 10/31 of 1994, and then also an outstanding subject is still Miles Nichols, October 31st, 1994. All of these individuals have been charged with felony murder as well as criminal street gang. So once again, this was a partner in act. This was a lot of collaboration, a lot of partnership, internal and external in the police department to bring us to the resolution on this case. And as our chief and our mayor has indicated, gang activity will not be tolerated in our city. Violent crimes will not be tolerated in our city. This incident occurred on March 14th, and you already see where the chips have fallen. Both.
Jimenez, he was a good one. He would have been good if he would have been in the trial more. He wasn't there that long, though. He got severed, remember, with YSL Polo, the one that was acting crazy in the courtroom.
I don't want to get into the weeds because we're not here to kind of cross-examine the intricacies of it. But you know, for example, that the science tells you that a location can be determined, or a cell tower can give you a location based on the signal coming to it from the device, right?
Right, the communication between the tower and the device.
Right. You also know, of course, that sometimes a signal from a device can bounce off of one tower to another tower when the device is being used. You know that.
Like a handoff?
Yeah. Yes. Okay. Now.
That's Miss D. Williams talking about her OnlyFans. I think I got one more clip coming up with her. We're saying it again.
So that brings me then to my question about how you're able to determine the general accuracy of a location. Right? When you look at the cell site data, you generate a map, and you see either a general location, as you described it, right? You see a general location, whether you're able to determine the accuracy. Is there a mechanism for determining the accuracy of that? In other words, can you determine whether or not it actually bounced off of one tower or another tower? Is there a way to test that?
So, in the CDRs themselves, again, depending on the carrier, they will show whether multiple towers were used. AT&T, for example, will show every cell site that one call may have used. So, yes, you can see handoffs there. T-Mobile may show a first and a last cell site, so how the call was originated and how the call was terminated. Typically, they're the same. Split the same. First cell, last cell. So you can see handoffs better with AT&T, but then you will see, like I said, first and last cells with other carriers.
All right. Do you know, if I use the term error rate, you know what I'm talking about? Mm-hmm. All right. Do you know, for example, if there is a way to test what the error rate is of any information that might be provided by the provider that details a location or a tower? Or
the specific error rates, I would say, depend on the carrier. Sprint, for example, to me was a little bit, had a higher error rate. Percentage-wise, I couldn't tell you, but it's all in kind of the evaluation of those records, too. You want to see abnormality.
Yo, I just dropped Cat Knot Williams' link in the chat. Y'all go and sub up, even though I'm sure most of y'all, probably about 99% of y'all already subbed up to Cat Knot Williams. But if you're not, hit the link in the chat and go show her some love. Appreciate Cat Knot Williams around here. That's family.
When it comes to cell site information. So if I see that there was several towers in downtown Atlanta, and then 30 seconds later there's a cell site that's used miles away that is physically impossible, that to me shows an error rate with the records, and it can be explained. But as to, I can't give you a percentage of what the error rate would be. But yes.
Would it be fair to say then, and obviously you don't work for the companies, but would it be fair to say that you cannot give us a specific error rate for Sprint versus AT&T versus, I don't know, Verizon might have been enveloped by somebody else?
What up, Becky? I see you, family. Rainy Rain, what up? I see you. Appreciate you joining. See y'all in the house. Let's get it.
Would it be fair to say that you can't give us a specific error rate for the individual carriers?
A percentage-wise, no, I don't. It's all in how, again, you interpret the records, as well as there are things to account for, too, when it comes to like attenuation frequency as well. So mirroring and shadowing and objects, the environment exist that affect radio frequency and affect the signal between the device and the tower. So
Which would make it difficult to determine, in this case, a particular error rate of any records that would be provided by the carriers.
Correct.
Okay. Just a few more questions for you. I think I heard you say that this technology and methodology, that's what I'm going to keep using, is used by other agencies, right?
Correct.
You reference APD, FBI, and some others. Are you aware of whether those particular agencies have any procedures in place for the testing of the accuracy of the information they receive from the carriers?
Well, when it comes to testing the accuracy of the information from the carrier, are you trying to say whether the information was correct when the carriers gave it to the
What up, Miss D? And cool, we got you, Cha. Go ahead, do your thing. We got you.
agencies or their interpretation?
That's what I'm asking.
When it comes to whether this voice call was accurate in its time or date, I don't know. But when it comes to the interpretation of the cell site information, so determining a general area, they can perform drive tests and determine what the strength of a particular tower may be.
Do you know, though, whether or not agencies that you've referenced, for example, APD, FBI, the others that you're familiar with that have quote, used this technology, whether they do in fact have procedures in place for the testing of the accuracy of the information received?
I think this is an answer. I think you just
Yes, that's an answer. I'll stand objection.
All right. I didn't get the answer. I guess the answer is they have it in place, but you don't know how often they use it or anything. All right. You were asked in regards to the records that you took a look at. We're talking about in the case involving a gentleman by the name of Javon Fleetwood.
Correct.
Do you know what agency, what carrier was involved in that particular case?
Steph JK, what's good, family? Appreciate you.
Analysis.
I do not recall if it was T-Mobile or Sprint.
All right.
There were several records that we obtained from that case. One was definitely T-Mobile, but again, Mr. Fleetwood's, I don't recall.
All right.
For my report, I could tell you. But
do you have your report anywhere in front of you?
I do not.
All right. That's right. That's all I've got. Thank you.
Okay. Anybody else? Mr. Jimenez, go ahead, sir.
Good morning, Good morning,
Good morning, sir.
City Child Academics on behalf of Mr. Dorsey. How are you, sir? Good morning.
Good. How are you?
Good. All right. I want to just add a few questions. Now, you say you received these data from the cell phone carriers. Is that right?
Correct.
Steph JK said thug free, y'all. Yeah, we gonna get into it.
And this data was created. This is kind of like, it's a data dump. It's just metadata they give you everything. Is that correct?
I wouldn't say everything, but the date and time of the call, who the call party was, how long the call lasted, again, the cell site, the sector of the cell site. So, yes.
And when you say cell site, the reality is that there are millions of cell towers throughout the United States. Is that right?
There are quite a few.
And the phone company doesn't own any particular cell tower. Is that right?
Own? I mean, they may contract out for property, but maybe I'm not understanding.
Let me rephrase. One cell tower could actually share and be used by multiple.
Absolutely.
And then so whoever controls that data then gives it to the cell tower, again, then gives it to the phone companies. Is that right?
Well, the phone companies will they have a retention in place where they and they also service the antennas that are attached to these cell sites. So, I mean, this is just records. I don't know the intricacies when it comes to who gives who the records inside that company. I don't know how to answer that.
But you said during that whatever records they do have, they collect them for their own use.
Right.
For example, they collect it for billings purposes.
Right.
Also.
That line of questioning, I don't think you can testify live on companies.
I want to throw some Jimenez in there because we didn't really get to see him too much. So I just want to get a little bit of him up in there.
Records, he's not a phone company.
I think he just answered it. He does know. If he knows, he can answer it. If he doesn't know, he can say, I don't know.
Okay. Well, can you answer that, Mr. Orr?
The records initially, when I would say there are many factors when it comes to why the records were kept by the carriers, one of which was originally billing when like I said, when we would have a limit on minutes or texts or things like that, but as well as they use these to know if their product is also working. So they determine whether there's a dropped call and kind of just the status. This is just in-house records that they keep. This wasn't developed to track or do anything like that.
So it was not developed to track their clients. Is that right?
I don't know when it comes to their intentions. I would say that because of the nature of the records themselves, it shows location information. I don't know the conversation that a carrier would have in regards to like why we're keeping these records. But I would say when it pertains to law enforcement, they don't retain these records so that they can just give them to law enforcement for law enforcement to track. What they do with their records is their business, but we know that they exist, and so we request them when it's necessary.
So let me pivot a little bit from what you just said right now. Law enforcement gets these records for them because you know they exist. Is that right?
Correct.
And to get them, you actually have to either subpoena or get a warrant.
With cell site location information, search warrant, yes.
Okay. So they don't just freely give it to you. There's actually a process.
Correct.
Now, you received quite a bit of training. Is that right?
Yes.
You listed a number of years, thousands of hours that you received in training, specifically as to cell tower location.
I would say my total number of training is close to 2,000. I wouldn't say that's all dedicated towards this type of technology.
That's right, that's right. Show TSC some love. Drop TSC some slime brothers with a T and a C or a T or some. Show her some love.
And is it fair to say that all the training related to this type of technology has been given to you by either a law enforcement agency, the FBI, or some other company that is in the process of helping law enforcement? Is that right?
A company, they'll help law enforcement. They'll help, I think, anyone that requests their help. I don't know who their clients are, but could be.
Have you ever gotten training by Verizon?
No.
Have you ever gotten training by Sprint?
No.
Have you ever gotten training by T-Mobile?
No.
So the actual phone companies, the ones that have these records, have never trained you on how to use it?
Correct.
All right. All the programs that you mentioned, these are third-party private companies, is that right?
Correct.
They are not the phone providers.
Correct.
And what they do is they take this metadata and then they make it pretty into a map. Is that right?
They will, yes, map the data.
So it makes your job easier. You know how to do that.
Correct.
You can look at one location, you can look at a second and a third, and then you triangulate where that actual phone may be.
No, I don't do it in regards to you seeing multiple cell sites that were used by the device. I don't triangulate. I show the cell sites, and then you will see, I will map the neighboring cell sites for that carrier. When I don't triangulate.
So
that's getting more specific. That's actually trying to show a specific location.
Do you know how to do that?
No.
Okay.
That's not what's done with CDRs.
Okay. Now, you are aware that there are apps or softwares that can emulate another phone number. Is that right?
Correct.
And then you're only going for the phone number. You're not actually looking for the device. Is that right?
For CDRs with CSLI is the phone number. Yes.
So if somebody's emulating.
I'm not saying for this line of questioning. We're just asking if the science itself is reliable.
Yeah, I mean, this is all cross-examination, Mr. Jones.
Yes, Your Honor. And if I may respond, when
it goes to weight, it doesn't go to the criteria of admissibility of the science itself. That's the only thing that this is a threshold under Daubert I got to decide. So
absolutely, it definitely goes to weight, and we will challenge that at trial. However,
yo, FFS, he needs some more subscriptions. Y'all want Jack to dance? He dance for subs. He like, it ain't enough subs. I ain't dancing. Appreciate the love, family. Hit the like, hit the subscribe, tap in, share with a friend.
this is the gatekeeping phase to make sure we're not getting any junk science in here. I mean, it is, just because law enforcement has used it for thousands of times doesn't mean that it is good science. As counsel for Mr. Williams was asking, there is error rates. There are issues with this data. And it is not data that they're creating. It is not even data that is peer-reviewed. It's just billing information, which I would argue to the court, it was never created to track their customers. And they are just looking at numbers, looking at metadata, and getting whatever they want out of it.
Okay, anything else, sir?
Nothing.
Okay. All right, thank you, sir.
Thank you.
Okay. All right, anybody else?
Yes. Johnson for Mr. Eppinger.
Thank you, sir.
Thank you. Good morning, sir.
Morning.
Based on the testimony that you gave earlier, you said that you received information, data regarding area. I couldn't
issue to be on the lookout for the white Audi
show you a map, and you can visually.
Video from the BP gas station less than a minute up the road would reveal everything police needed to know. Police issued to be on the lookout for the white Audi SB had been driving, and 3 days later, they'd locate the vehicle, which led Atlanta PD and Georgia State Patrol on a chase.
Yeah, he's pulling out to Cleveland Avenue exit. Alright, he's making a right turn westbound on Cleveland Avenue.
Okay, get us at the westbound on Cleveland.
And again, so everybody knows, it's a white four-door Audi. We are going to be in pursuit. We're currently westbound. Alright, he's pulling into a driveway. 2481 Meadowlark Drive. Driver is he got two running. Driver has a maroon colored beanie on, black jacket.
This is police following Shannon and Yak. It looked like they didn't even know they was behind them though when they first got out the car, right? Like they wasn't even running from them. The police was just following them. I'm not sure. Let me see.
Jacket, blue jeans. Way. 2481 Meadowlark Drive. Driver is he got two running. Driver has a maroon colored beanie on, black jacket, blue jeans.
Oh, never mind. I think he hopped out with his hands up.
They're both running northbound behind 2481 Meadowlark Drive.
I'm going to use caution. Shannon is to be on with over spoke. Go check that signs are dangerous.
Go in the house, go in the house. Go in the house. Why are you here?
Hold it, this is being
Hey, go up,
Everything here in a minute, man. Come on, bro. Yep.
They said, who the fuck is this nigga?
Hey, you want him in my car? It's the Saturn. Yeah, keep it separate. We're gonna go to that shit back there. How you run? How you run? What's your name? Wait, Marvius. What's your last name? Wait, Marvius Nicholas? Wait, Marvius Nicholas?
Hey, Nicholas.
What's your name?
29-year-old Shannon Jackson, aka SB, and 27-year-old Quamarvius Nichols, aka Quay, had thrown guns from the vehicle before bailing out. SB, Quay, Miles, and now Skyface have all been charged with Shymel's murder. And if you watch my previous video on YSL Woody, you'd know Scarface and Woody both identified SB as being present after the murder of Big Nut. Miles would attempt to get a bond as his lawyer claimed he was only a clothing designer and participating in nothing except riding in the backseat of a vehicle when the vehicle in front of the one he was in opened fire, implying that the shooter of Shymel was inside of the white Audi. According to surveillance video, SB was driving the white Audi.
During the YSL chaos at the Fulton County Courthouse during the YSL jury selection.
Sheriff Patrick Labat tells Fox 5 that a defense attorney was arrested before court.
What up, Mookie? I see you. Appreciate you, family. And y'all show some love for TSC with a gifted membership. Appreciate you, family. Drop a slime brother for TSC. And Steve, if you happen to be listening, show some love to TSC and say thank you for your membership.
Even started today. He's charged with bringing his own prescription drugs into the courtroom. Fox 5's Angelique Proctor joins us now from downtown. Angelique, what happened there today?
Well, you know, Tom, this story leaves you asking the question, what will happen next? Yesterday, it was a defendant who was arrested for allegedly having marijuana in his underwear. Today, it was a defense attorney arrested for allegedly bringing prescription drugs into the courtroom. Fulton County Sheriff Patrick Labat tells me that contraband is a big problem during this YSL trial. The YSL racketeering trial has taken some bizarre twists and turns. Fulton County Sheriff Patrick Labat confirms a defense attorney was arrested Thursday morning for bringing prescription drugs into the courtroom. The top cop says attorney Anastasio Manates also threw his cell phone at a county captain. Attorney Sidai Jimenez says he was standing at the security checkpoint when all of this unfolded.
He had his own prescription medication in his bag. And apparently they detained him for that. His prescription drugs, and it's his business. It is nobody else's business what he's prescribed to, who prescribed him, what's his doses. Those are his medications.
The defense attorney also faces battery of a law enforcement officer for allegedly throwing his cell phone.
I'm standing right here, and the deputy's standing right here. He tosses the phone at me because he gets jammed. The phone tapped the deputy. So I believe they also gave him a charge of a simple assault on a law enforcement officer.
Shout out to TSC for the gifted. I see the photos working now. Appreciate you, family.
The sheriff says YSL defendant Rodelius Ryan was screaming yesterday because deputies had discovered 2 bags of marijuana he allegedly had sewn in the second pair of his underwear. The judge says defendant Ryan will be severed from this trial, now leaving 13 defendants. And defendant Ryan will be charged with that marijuana. As for the attorney, we are told he is still in the Fulton County jail but hopes to bond out soon.
Counsel representing the state agency head tried to get the judge recused. That did not happen. What did happen is that it gave more attention to attorneys who say they are being grossly underpaid. Attorney Angela DeWilliams is one of multiple attorneys contracted by the Georgia Public Defender Council to represent defendants in the YSL trial. The council is a taxpayer-funded state agency obligated to provide attorneys to people charged with crimes who cannot afford one. DeWilliams believes the council's pay is not enough due to the complexity of the case and how long it's expected to last. To put in perspective, the state has only agreed to pay attorneys $15,000 for a murder case that could require
$15,000 for this case. Could y'all imagine that? Yo, shout out to KCJ. You have the most supportive viewers. Must mean you're awesome. Appreciate that, family. I would hope so. I do have the greatest supporters, and I appreciate y'all. Appreciate y'all for sure, for sure. 15,000. Man.
them to attend court nearly every day for a year. That's less than what some fast food workers make. DeWilliams says she's repeatedly asked to meet with the director of the Defender Council, Amatei Ali, to learn what the agency's doing to address the pay. When Director Ali declined, the attorney subpoenaed the director, trying to force her to answer questions about the pay in open court.
Initial burden of showing the document.
It is frustrating, but we were under the impression that GPDC was advocating for us. And once they put those walls up, I'm thinking maybe I need to start an OnlyFans. I'm very serious, yes. I might have to do an OnlyFans because at least I can still support my client and support me and my family.
Now, if you are not familiar with OnlyFans, it's an adult website where people go to sell pictures and video of themselves. That same attorney that you just saw has now agreed to give the Defender Council one more week to meet with her to discuss the pay issue. The defender counsel agreed.
First of all, good afternoon. I believe both Madam DA and Chief Bryant are really raising the level of consciousness in what we're doing within Fulton County, and certainly they deserve our appreciation. With respect to the specific question as to safety and so many people being brought in, we are housing them accordingly to include other facilities. So I encourage everyone to really download the Sheriff's app if you want to know specifically where individuals are, and you'll be accommodated accordingly.
Sheriff Levine, like I said, jumping to the indictment, there was an element of it where they were talking about Quantavious Greer communicating with an inmate, where the inmate had a cell phone that was contraband.
It's kind of hard to hear, but he asked about Young Thug brother, Quantavious Greer.
But it was clear from the indictment that you had been, or that all of you had been, monitoring that conversation. But it leads me to ask a question you're probably not going to answer. Was that cell phone deliberately given to an inmate so that those conversations could be monitored?
So I did have an opportunity to read your editorial that you posted in the Buckhead blog or whatever it was from that perspective. And so you're right, I'm not going to answer that. So, appreciate it. We'll leave that to Madam DA.
Can you tell us of the 28 who were indicted, how many have been arrested, how many are large, how many are already in custody?
You know, and I do not have that exact number. I can tell you approximately 10 were already in custody. I believe as of last night, we had arrested at least 3. As of last night, I expect to see more arrests today and in the upcoming weeks, but I'm realistic. It's probably going to take the next 2 weeks to get everyone in custody.
There's been some discrepancies about where the gun is. Maybe this is better for the sheriff. Where he's being, is he in custody?
Short answer, Michael. He's not in custody.
Okay. I mean, is there been arrangements for him to surrender, or is he considered a fugitive right now?
Well, we're making arrangements as much as he had representatives call me last night directly. So we'll muddle through that piece and let you know. And again, download the Sheriff's app. Make sure.
Sheriff, one more question.
Yes, sir.
Have you had to take any special precautionary measures at the jail in light of high profile? I mean, you mentioned people being housed differently, but just safety for your corrections officers, and what kind of, are you able to reveal some of the things you've had to do in light of?
And that's a great question, and I appreciate you taking the time to come visit us a couple of weeks ago. To that extent, based on some of the things that we found, we've already begun new procedures. And so the opportunity for us to maintain safety is paramount. Thank you.
Follow up on Michael's question with the indictment and names being out there now. Are any of the individuals considered fugitives? Is there a worry that some of them are on the run now because they know that they're indicted?
In this business, I'm certain that there will be some people that won't volunteer to come into custody. There is no concern that somebody will escape being arrested.
One last question, I'm sorry. How significant was the arrest of Christian Eppinger with regard to the...
Long ago, a time-sensitive importance or significance to this particular case. I was a prosecutor, as you know, for 16 years, 4 months, and 4 days in this office. The murder of Donovan Thomas in 2015 created violence like Atlanta has never seen. It was a goal of my predecessor and any person or prosecutor in this office to make sure that that family received justice, because everyone is entitled to justice. It was a commitment I made from the first day I walked into this office. Very shortly after me becoming the DA, I sat down with Mr.
Her ass. Hey, you seen her YSL Tara? I mean, oh boy, he was like, for those who don't know what OnlyFans is, it's a website where you can sell your photos.
Mr. Thomas's mother, and I made her a promise that her son was as valuable as any other person within our community, and that I would put resources on this case, and that I would do everything I could to make sure that her son had justice. And yesterday was a proud day for me.
Was there any connection between the killing of YOUNGTHUG's children's mother and this gang?
I don't believe any. Thank Thank you.
YOUNGTHUG shared a message to fans from jail. The rapper appeared in a video that was played for thousands of people at Hot 97 Summer Jam this weekend. YOUNGTHUG, whose real name is Jeffrey Williams, thanked his fans for the support, but also urged them to sign a petition that calls for legislation at federal and state levels to limit the use of art as evidence in criminal trials. In the 56
Why did they show that as part of the video? Why did they put her in there?
Count indictment against Williams and the criminal street gang The Young Stoner Life. Several of Williams' lyrics are being used as evidence in the case against him.
This isn't just about YSL. I always use my music as a form of artistic expression. And now I see that black artists, rappers, don't have that, brilliance. There's not a clean time to protect black art artists and keep friends with us. I love you all.
Many notable figures in the music industry have come to Williams' defense and are also calling for the protection of black art. So far, the petition on change.org has reached close to 27,000 signatures.
Yak Gotti. They were indicted along with fellow artist YOUNGTHUG and more than 24 others. Prosecutors say their gang has links to violent crimes, including murder. CBS 46's Haley Mason live at the Fulton County Jail with more details tonight. Haley, good evening.
Good evening, Sean. 2 more Atlanta rappers booked into the Fulton County Jail behind me, indicted on allegations of being involved with gang activity surrounding the YSL gang. But now community members and attorneys are speaking out, questioning if the mass arrests of possible gang members will really make a difference in tackling Atlanta crime. Rapper Yak Gotti, whose real name is Demonte Kendrick, is charged with participating in a criminal street gang. Rapper Gunna, whose real name is Sergio Kitchens, is charged with the same. I talked to Gunna's attorney, David Samuel, about the charges. Samuel didn't want to be recorded, but disagreed with his client being depicted as part of Atlanta's crime problem.
Just reading the indictment itself and nothing more, it is so clear that he is entitled to bond. He has no felony convictions of any kind. We're sitting here in jail at this point on a RICO allegation involving 2 motor vehicle offenses plus lyrics.
Fulton County DA Fonnie Willis is using the racketeering charges to tackle gangs more broadly in court. She says nearly 80% of crime problems in metro Atlanta are rooted in gangs.
If you're asking, should you expect to see other RICO indictments against other street gang organizations? Absolutely.
Willis says she brought down indictments on the YFN gang a month ago and is now going through the YSL gang, which is affiliated with the Blood Street gang.
It is a significant gang that operates here in Atlanta, Georgia.
These arrests, Willis believes, will help stamp out some of the violence, but Attorney Maoli Davis, who works with at-risk youth through his organization, the Black Man Lab, says tackling gangs...
All right. Appreciate you, family. Yeah, I don't mind you sharing. I appreciate the love. It helps us out. We're going to get into the end of the Thug plea hearing real quick, and then we'll come back to the rest of what I have planned on here. Appreciate y'all, family. Let's get it. Just a second. I'll play this while I'm loading that up. Oh, actually, I got it ready. Let me see, right here.
Asking, Your Honor, on count 1, which is the RICO count, to accept the nolo contendere plea. Please sentence Mr. Williams to 20 years to serve 5 years in prison commuted to time served. Mr. Williams has served, as I said, 22.5 years. On count 56, Your Honor, that's the leadership of a gang, nolo plea, 20 years to serve 5 years commuted to time served, consecutive to all other counts. On count 57, which is a gang count, Your Honor, not a leader, guilty plea, 20 years to serve 5 years commuted to time served, concurrent with count 1. With regard to count 58, which is possession of, I believe it is marijuana with intent to distribute, 10-year sentence on probation, concurrent with count 1. On count 59, which is violation of Georgia Controlled Substance Act, possession of codeine with intent to distribute, 5 years on probation, concurrent with count 1. On count 59, Your Honor, which is violation of Georgia Controlled Substance Act, possession of cocaine, 3 years on probation, concurrent with count 1. Count 61, 5 years of probation. It's a firearm count, consecutive to the other counts, consecutive to before count 56. And then count 62, 10 years to serve commuted to time served. That should be a total sentence, Your Honor, that we are respectfully requesting the court to consider. I believe it's 45 years to serve 5 years in prison, commuted to time served, 40 years on probation, credit for the time already served and community time served. As I said, after 3 years of probation, the probation becomes non-reporting, and after successful completion of 10 years on probation, the balance of the sentence be terminated. Mr. Williams asked the court for house arrest for 3 years as part of the sentence, but house arrest specifically defined that Mr. Williams will be in his home or at any lawful employment, touring, studio, performance, business meetings, and the like. Wear an ankle monitor for the...
Miss 2T said she didn't even get to go trick-or-treating. Her mom used to buy candy and put it in the bucket and make them stay at home and watch scary movies. Shout out to 2Ts.
The first year and pay the costs of same, and the company must be approved by probation department, and the ankle monitor to be affixed within 10 days of hopeful release from custody. Mr. Williams could not possess a firearm, but he can be around licensed security who are armed or other persons who are lawfully carrying a firearm with a license. And that would be knowingly for Mr. Williams. Mr. Williams can transfer probation outside the state of Georgia. He has residences in the state of California. He has studios in the state of California. Mr. Williams be allowed to travel throughout our country and the world for lawful work-related industries. Mr. Williams wants to perform. He's going to do this anyway, Your Honor.
Shout out to Cha Diggy holding it down for the mod. Y'all show Cha Diggy some mod love and drop some blue hearts in the chat with some slime emojis. Appreciate you, family.
But we made it part of the sentence. At least one concert each year at a venue, if they'll have him holding 10,000 people, if that is workable for the venue. Mr. Williams' management, and he is going to donate all of the profits that he makes to a 501c3 charity. Mr. Williams wants to pledge $100,000 for the next 3 years to the Fulton County Sheriff's Office if they will hold an illegal firearm buyback to buy back firearms that are not supposed to be on our streets. Mr. Williams does not
have a great night, YP Chick. Appreciate you.
Wish to go near the Cleveland Avenue area, not to insult that area at all, but it is just not a good idea under this circumstance. And he can drive on the highway, but otherwise not come within 1 mile of the area that we call Cleveland Avenue, and we can give the exact dimensions of that area. Mr. Williams must perform 100 hours of community service per year for the next 3 years as designated by probation department. Mr. Williams can associate, and this was agreed to previously, with people who are convicted felon or alleged gang members solely for lawful purpose of making music.
I see Ms. Love shaking her head, and I think it's fair to establish that until the entirety of the negotiations were agreed to, it was all up in the air.
Sure.
That may have been something y'all had already hammered out, but it wasn't. It's not anything they're bound to.
Absolutely.
Fair. Okay.
I agree with that. Mr. Williams can have no contact with any of the supposed victims, and there was an Exhibit A attached to the state's proposed plea agreement, negotiated plea agreement that was sent to you, so we adopt that Exhibit A, but we can give it to the court if you need those names. And Mr. Williams have no contact with any of the co-defendants in this indictment, with the exception of Mr.
Hey, appreciate you, Becky Einhorn. Appreciate the love. I've become fond of your company as well. Appreciate you.
Tavius Greer, that is his biological brother, as well as Mr. Sergio Kitchens. He's a phenomenal artist. He goes perform known as Gunna, G-U-N-N-A. Mr. Williams and Mr. Kitchens are contractually obligated, and they frequently perform music together. Your Honor, any other conditions that this honorable court deems appropriate? I want to thank the court for all your time, always. I want to thank Ms. Percival for everything she has done. I want to thank Mr. Williams for allowing me to stand with him. And I really never thought we would be here, but this is his decision. I want to thank the Honorable Keith Adams, who may want to speak, Your Honor, but I can never imagine a better lawyer than Keith Adams.
Mr. Adams, do you want to add anything to the record?
Your Honor, I don't know that there's really much to add. Mr. Steele has represented to the court, I think fully and thoroughly, the breadth of our knowledge of the case Mr. Williams' background. I think the court has not just heard it from Mr. Steele, but has had the opportunity to sit here and hear some of the evidence and kind of get a feel. You've had a chance also to observe Mr. Williams and then get a feel for him, his background, and so forth. You know, the only thing I can say about Mr. Williams that hasn't been said is that he comes from an area. You might have heard throughout the course of the trial that there was an album, a concert tour. We came from nothing. And that is true. Mr. Williams came from, you know, I hate to use the word abject poverty, but that really is the case. Came from an area where there was a significant amount of crime, where, as you've heard, he's had tragedy in his life and has observed tragedy in his life, and he has gone through a good bit. He has been involved in a lot, but he has raised himself up. He has done the best he could and has done phenomenally well, and is, I think, an inspiration to a lot of people from that community who look to him and see the success that he has gained. And have been fully supportive of him. But he finds himself here. He's in front of you. He is tendering his plea because he accepts responsibility. You have heard everything Mr. Steele has had to say. I can only ask that you follow what we have put before you. You also have, I believe, the paperwork that was given to you by the state, which kind of gives you some idea of what they were looking for as well in terms of conditions on Mr. Williams if we were to ever reach some sort of agreement. And we ask that if you feel that there's anything within the state's proposal that might be appropriate in terms of the sentence for Mr. Williams, that the court please feel free to do that. There's nothing that he puts himself before the court. And I think 2.5 years sitting, going through this process, challenging the process, but now standing before you and asking that you consider everything and sentence him appropriately in the way that we've requested. I'd simply ask you, I'd join Mr. Steele and Mr. Williams in asking you to do the same. And I thank you as well, as Mr. Steele did, for your patience with us and for bringing some order to the proceedings that candidly was.
Steph JK, hey, drop some ice cream emojis for Steph JK. And while you at it, drop some FFS for FFS. Where you at, family? Drop some of the FFS emojis. Show them some love. Appreciate y'all, family.
Needed. So that's all I have to say. I thank you again, and I ask you to consider everything that's been put before you.
All right, Mr. Williams, is there anything that you want to say?
Yes, ma'am. I take full responsibility for, you know, my crimes, for my charges. I want to say sorry to my family, my mom. My mom got 11 kids. I can't say all the names, you know. My managers, my kids that's not here. Really, everybody that got something to do with this situation, I want to say sorry for just, like, you know, having so much time invested into this, you know. And I am a smart guy. I am a good guy, and I really got a good heart, you know. I find myself in a lot of stuff because I was just nice or cool, you know, and I understand.
Hey, Bahira at Rock Essa Bay, what's good, family? Appreciate you joining.
And that you can't be that way when you reach a certain height, because it could end bad, and it don't really have to have nothing to do with you, but it could end bad, and it could, you know, fall on you. And I know the choice is yours, it's up to you, and I hope that you allow me to go home today. And
Shadiggy said even the animals celebrating outside.
And just trust in me to just do the right thing and never see you again unless it's at a, you know, bar in the future or something. Just out of this type of situation, I promise you I won't ever be in this type of situation again. I'm going away. I've learned from my mistakes. You know, I come from nothing and I've made something, and I didn't take full advantage of it. I'm sorry.
Free Moon too.
Through these last 2.5 years of my life, you are really, truly, honestly, the best thing that has happened to me, because you made everything fair for me and everybody involved on both sides, you know. I'm sorry to the sheriff, you know, everybody, for just having to put extra time in. I know y'all got paid more money, but I'm sorry for y'all having to put this extra time in to be away from y'all family, you know, and I just hope that you find it in your heart to allow me to go home and be with my family and just do better as a person. I know what I bring to the table. I know what I am. I know the heights I've reached. I know the impact I got on people, period, in the community, you know, all people. I learned that late, like these past 2 or 3 years of my life, I kind of learned that late, and maybe it was because I was, you know, probably on drugs or anything, I don't know, but I have came to my senses and I understand what I mean to this world. But I am a good guy, you know. I don't mind doing stuff like, you know, like free shows, and I always did that. You know, I did free shows and gave it to single parents, millions of dollars. You know, I made $1.8 million on a free show, and I gave it all to single parent charity. And I did like 2 or 3 shows that made like $700,000 a piece, and I gave it to the breast cancer organization. Like, you know, I do things. I put millions of dollars back into my community for real. I really did. I did more than anybody ever did from my side, you know. But I understand.
What up, Joni 4? I see you. Appreciate you, family.
You know, rap lyrics, I understand how it could be twisted. I understand what it could do to the mind of people. I understand all that, and I promise you I'm 100% changing that. You know, it's just, I'm older, I'm grown now, you know, and it's just like, I'm smarter. There's more things to rap about. Like, I've experienced a lot of good things. I experienced more bad things, but I experienced a lot of good things too. And anyway, I can go forever.
Well, I appreciate it. And I appreciate that you do realize how much of an impact you have on people. I mean, it's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around that, you know that gangs are damaging to our community. And it may be that a whole lot of rap music and the rap industry is, I mean, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap. But whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool, this is what I want to do, look at him, he's a millionaire, I can do that by being, you know, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or you get thrown in prison. And those are, you know, by far the most likely outcomes. And you know, you've been in here watching the trial, and you've seen the pictures of Mr. Ryan posing with a gun as big as he is at 15 years old and going out and shooting and killing another teenager. And that's what gangs do, and that's unfortunately a lot of what rap music does. And if you are a modern day John Lennon, you know, I mean, he might have rapped too in this day and age, I don't know, but I know you're talented, and even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs. And, you know, I know that happens for protection sometimes, but a much better way would be getting an education and setting, you know, hanging around with people who set a good example. And you be one of those people that sets a good example. I mean, all right, so that's my high horse on that. I could also go on. But I want you to try to be more of the solution and less of the problem. All right? All right, so it is not lost on the court that the state, had they been able to come to agreement on
Shout out to Jerome Street with the new profile pic.
certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, you know, machine gun count, was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be.
Right. What kind of... that don't even make sense. They retarded. What up, One Nation? I see you, family. Appreciate you joining.
Particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration in crafting my sentence. And in permitting a NOLO plea to the RICO count in one of the two gang counts, I would not be permitting the NOLO to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged. I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution.
AOBD, what up?
On count one, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count two, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count one, but I am going to backload. Oh, I'm sorry, that is not commuted. That is 5 years to serve, and it's going to be run consecutively to count one, backloaded, by which I mean after you serve your 15 years of probation. If you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count. Count 57, 20 years to serve 5, commuted to time served, the balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served, balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served, concurrent with count 1. 60, 5 years to serve, commuted to time.
Yeah, I'm down to do panels. I haven't really done none. I can do it. I just haven't did it yet. Appreciate you, Joanna. Future panels coming soon.
Served, concurrent with count 1. Count 61, 5 years to serve. That is required to be also a consecutive sentence, so that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively. That's
No, he not getting no money back unless it was, except for the money they illegally confiscated, like in the illegal search and seizure money.
It's going to be consecutive to count 61, also backloaded. So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served. You are to remain on reporting status for the first half of your probation, active reporting for the first 7.5 years of your probation, and that is pursuant to OCGA 17-10-1, subsection 2, A2A. And Mr. Steele and Mr. Adams, in order to keep him on reporting status, there needs to be good cause shown. We all concede that good cause is shown here?
Stipulate.
All right, I appreciate that. Special conditions of your probation.
What good cause? What do you mean?
Can I have a second, Your Honor?
Sure.
Thank you, Your Honor.
All right. You had enough time to talk with your attorneys?
Yes.
Yeah, his property. Anything they seized, yeah, they got to get that back. Yeah, for sure.
Okay. All right, special conditions of your probation. After 48 hours from your release, you are to stay away from the metro Atlanta area, and that's defined by the U.S. Census Bureau. It may change, but you can look that up anytime to figure out what that is. For the first 10 years of your probation, subject to the following exceptions, you are permitted to be in the metro Atlanta area to attend any wedding, funeral, or graduation from high school, college, or graduate school of any of your immediate family members. And immediate family members is defined.
Pink Slime, what up, fam? I see you. Appreciate you joining.
The same way that you all were contemplating it when you were negotiating. You can get here up to 24 hours prior to any such event, and you need to leave within 48 hours after any such event. In addition, during each...
Oh, that's a fact. Hold on. He did plead to the RICO. That's a fact. He did plead guilty to the RICO. So, nah, they keeping all that. He can't come back and fight it either.
Each year of your probation, I'm going to require that you come to the metro Atlanta area and make a live anti-gang and anti-gun violence presentation 4 times a year each year of your probation at a grade school, a middle school, a Boys or Girls Club, anything like that, that type of group. And if you want to, that presentation can include a benefit concert, and these presentations may count towards your required community service hours, which I'm going to impose, that during each year of your probation, you perform 100 hours of community service. You are, and this is required by the fact that there's a gang conviction. You shall not knowingly have contact of any kind or character with any other member or associate of any criminal street gang. Exception to that, if your brother is a member of any street gang, I hope you talk him into getting out of it. Quantavious Greer, and then also Sergio Kitchens, as long as you are contractually obligated to him. That is going to include anybody who is named in this indictment, except as absolutely necessary to conduct the lawful business of your musical career, and to any extent that the state is not agreeing to the exception for Mr. Kitchens.
Yeah, I don't know why. A couple people have been having problems gifting memberships. I don't know what's going on. But I don't know. I could put my Cash App. If you want to send it to the Cash App, I could get the memberships for you. But other than that, I appreciate it. Anyway, I appreciate you trying.
In the event that that part is not enforceable because it is only a portion of a special condition, I'm going to provide that that be severable from the rest of this, and I'll put some case cites in the Senate sheet for that. You are in no way to promote any criminal street gang or any criminal street gang activity, including on any social media platform. You are not to utilize any hand signs, terminology, or language that promotes any criminal street gang. You are not to participate in any criminal street gang activity. You are not to knowingly engage in any contact with any of the victims that are listed in this indictment or with any of their family members. And you may not have in your possession or with arm's reach any kind of a firearm because you're going to be a convicted felon. And that is, except I know that you have security and you need security, you can be within arm's reach of a firearm that is in the possession of either licensed law enforcement or licensed security personnel that are in your security detail or anybody that you're performing with. You are to submit to random drug screens and not use any drugs unless they are prescribed for you by a licensed physician. You are to execute a Fourth Amendment waiver that will permit the search of your person, residence, vehicles, and electronics for any firearms, any criminal street gang paraphernalia, or any illicit drugs. And as I mentioned, with regard to one of the first of your co-defendants from this trial, at least since I've been involved, to plead guilty, our Uniform Superior Court rules instruct and provide that it is absolutely proper for a judge to grant leniency in sentencing when, quote, the interests of the public in the effective administration of criminal justice are served, unquote. And I think that this plea is in the interest of the public and in the interest of effective administration of justice. Have been trying to ensure that, to the extent I can, this trial also abides by that. It's been challenging at certain times. I find your plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I accept it as such. I also need to inform you that your attorneys were going to represent you through either the last day of this term of court or 30 days from now, whichever is later, and any of the filings that were mentioned that need to be filed within that time, they would file on your behalf unless they are permitted to withdraw from representing you before that time. I am not going to impose the conditions suggested by your counsel about the benefit concerts and the donations to the sheriff's office, but I certainly strongly encourage you to do those things and to do and continue to do things that benefit your community and especially help young people to stay out of criminal trouble. And unless there is anything from counsel other than that.
I have one matter, Your Honor.
Okay, and does the state as well?
Yeah. Your Honor, with regards to Mr. Williams being permitted to come to the Metro Atlanta area or Cleveland Avenue area for a funeral or the other items,
right.
Can you also consider, God forbid, there's a serious medical condition of a person that
in
is...
his immediate family, yeah. Certainly, we can add that. And I also meant to mention, because I know you do travel all over in order to pursue your career, that it's permissible for your probation to be transferred to out of state, and that has to be done through probation, but that is fine with the court. And you may also keep your nobody's.
That means he could move up out of Atlanta too. Get his ass up out of Atlanta and move somewhere else, so he ain't got to be around that anyway.
But keep your passport and travel out of state and internationally to the extent that you need to do that for business purposes as well. All right, Mr. Body.
Yes, very briefly. Thank you. The district attorney just wanted me to urge the court, due to the fact that the Thomases have been negatively affected incredibly traumatically by.
And look at this fool. They always gonna try to do some extra shit. Like, can we get the witness statement in?
Thank you, and I appreciate.
Like,
well, I cannot even begin to understand what they must. Anybody must be going through when they lose a family member to violence or criminal violence. Mr. Williams himself has expressed his own sorrow to the family. I, again, am going to stand by my belief that the appropriate time to hear a victim impact statement from them is at the close.
I'm not sure if they can or can't. I'm hearing both sides, and I don't know no facts yet, so I'm sure he ain't tripping on that anyway. As long as he going home, he ain't caring about none of that stuff. He can make that back in one show, whatever they took. His first show gonna make way more than that.
Of the trial that contains the murder count with regard to their family member. All right, thank you. Okay, court is adjourned. Good luck to you. And I'm going to have there better be no violations, but if there are any, you're coming back to see me. All right.
Thank you, Your Honor.
Hey,
What up, Dream? I see you, family. Appreciate you joining. Yeah, that was a little clip of that. We could get back to where we was. Y'all make sure y'all go check out my cuzzo. My little cuzzo just dropped his new hit, Reggie Righteous. And yeah. He got a new banger, new visualizer out. We're gonna get right back into it. Appreciate y'all, family. Hit the like, hit the subscribe, tap in, share with a friend.
You don't have to catch a, you don't have to catch a body if you don't have to. Can't find solace with your past passing you.
He's now headed to prison for nearly 10 years.
Reading the indictment.
Courthouse during the YSL jury selection.
Sheriff Patrick Labatt tells Fox 5 that a defense attorney was arrested before court even started today. He's charged with bringing his own prescription drugs into the courtroom. Fox 5's Angelique Proctor joins us now from downtown. Angelique, what happened there today?
I think it is quite premature for Mr. Steele to object to what he believes is going to happen at trial when it's not something that will delay the trial for an inordinate amount of time, any more than an objection to a question that I may ask would delay the trial. So I would ask that the court.
There y'all go. There you go, family. Thugger free. He going home tonight. Well, he already at home. I think he should be home already. All they have to do is go and check out after that. You know what I'm saying? Get unbooked, and he was home. So he should be home by now for sure. Shout out to Thugger. Free the rest of YSL. Free Yak. Free Shannon. Free the rest of the 28 that didn't do the crimes. The ones that didn't do the crime, that did the crimes, I don't know. You know, let them have their day in court. But the ones that didn't do the crimes, free all them boys. And I don't know, preferably I would rather none of them have to deal with it, you know, have to deal with their own. But, you know, that's here or there, you know.
At the time that is proper, when that matter is raised at trial, address any objections Mr. Steele has to foundation or to content or to relevance when the evidence itself is tendered. And as to Mr. Steele's standing regarding the wiretap itself, I would argue that neither he nor Mr. Sharp have standing to.
My client is a lead person.
I'm sorry.
I certainly have standing to challenge the wiretap. My client is an aggrieved person under the statute, and so I mean that's pretty settled. Regarding the line sheets that Mr. Steele is speaking of, one of the grounds that I have raised in my motion regarding the wiretap is the minimization. I don't know how the state plans on putting off the actions of the monitors until trial. Obviously, they have the right to argue a motion however they choose, but if there are line sheets that do exist.
AOBD, have a good night, family. Appreciate you joining.
We need to get those to the defense prior to this motion to suppress being heard. That's my stance.
Well, it looks like under 24.9.901 that, you know, there's going to be some authentication issues that would probably have to be done to begin with. So that's what I asked the state about in terms of for the foundation. If it's going to be part of the foundation and like, for example, you wouldn't need necessarily somebody to kind of go through the technology of a wiretap, okay? But you would need somebody to at least kind of, if you're going to get in any of the other things about the voice of speaking and everything else, that's separate, of course. But the other stuff is just whether or not, you know, the warrant was or wiretap was procured correctly. I mean, I don't know what it says it was filed today, so I'll, of course, kind of take a look at it later. But I could see that there might be some foundation issues in regards to speakers and the identification of those. So so that's just something that you all need to kind of think about. But the other thing is, at the end of the day, those particular written summations, again, I'm going to charge a jury, at least I think I will, on the predicate of whenever you have like sound recordings and you have transcriptions. Of course, the sound.
Have a good one, fam. AOBD.
Takes precedent over the writing because we tell them whatever they hear. So at the end of the day, what's really the relevance of that?
I'm not using it for a jury like a recording versus the transcript, and the recording is the evidence, transcript is just an aid. That's not what.
What are you using it for?
In this motion, you will, I believe, Your Honor, is going to schedule on the wiretap, which, you know, I'm clearly interested in, has a minimization requirement. So what is being minimized? What's being listened to?
What has a minimization requirement? The wiretap itself?
Of course. Yes. You have to have, and it's set out in the rules. You can't listen to everything. If I'm speaking with Mr. Williams.
What rules are you talking about? Is there a particular statute that covers it?
Yes.
A federal statute? Yes. State statute? What is that?
Both of them. Let me just can I step back?
Yeah, you can.
Statute is
1611-64?
Yes, sir. But it incorporates the federal statute.
Look, Shard said,
What
I
is
got
that one,
you.
sorry?
Look, Shard, look, I'm going to tell you what happened right here. Hold on.
Let me just if I'm speaking with Mr. Williams.
What rules are you talking about? Is there a particular statute that covers it?
Yes.
A federal statute? Yes. State statute? What is that?
Both of them. Let me just can I step back?
Yeah, you can.
Look, he asked Steele to go. He was about to go get the code. Shard was like, I got it. And then Shard was like, he told Steele, I'm going to tell you what he told him in his ear.
1611-64?
Yes, sir. But it incorporates the federal statute.
Hold up, right here. He was like, look, he's supposed to be the judge. And how we smarter than the judge? He don't know shit. How you going to be the judge and you don't know shit?
What is that one? I'm sorry?
1611-64. 18.5.
Done in such a way as will protect the recording from editing or other alterations. The only time I see minimization is when you're talking about code or foreign language. Under the paragraph you gave me, under 5, and then it's got...
He don't got to go to have a probation or parole hearing because he was already in front of the judge. He got sentenced to 5 years. He already did two and a half. a little over 2.5, so they just commuted it to the time served. That's basically around the same amount of time he would have got anyway. So that's why they did that. They just wanted to get him on that RICO because the minimum for RICO is 5 years. So as long as they got him on that RICO charge, then they still win in funny eyes.
1, 2, 3, and it says, in the event of intercepted communication is a code or foreign language, and an expert in that foreign language or code is not reasonably available during the intercepted period, minimization may be accomplished as soon as practical after such interception.
Your Honor, Scott, the United States, 436 U.S. 128. But I will clear up what
Denied. Where in this statute does it show that there's a requirement for minimization?
There's definitely a requirement for.
All right, well, give me a case, or show me a case that requires it, because it seems like the statute here just requires that you provide the recording itself.
Your Honor,
so it looks like there is a minimization requirement, but that depends upon what is the.
See, you just put him on black. I skipped him in between, but he went from there's no minimization requirement, then he showed it to him. Well, it looks like there is a minimization requirement. Come on, Judge.
I guess, or what's recording itself.
Your Honor,
so it looks like there is a minimization requirement, but that depends upon what is the tape, I guess, or what's on the actual interceptions itself. So do you have this 11th Circuit case? Can I have that one?
Yes, Your Honor. And I agree, it is based on the interceptions, but it's also judges the reasonableness of the monitor.
Well, let me go ahead and let me have the 11th Circuit case, and I'll take a look at it. Order authorizing, every authorizing order must require the surveillance be conducted in such a way as to minimize the interception of communications not otherwise subject to interception. 18 U.S.C. 2518 subsection 5. The authorizing order at issue contains such a requirement. That's in the Van Horn case. I suspect I'll have to take a look at the authorizing order. It also indicates in Van Horn that the relevancy of the minimization would be that and the court had to look at it in this particular case is whether or not the appellants in Van Horn claimed that the agents didn't minimize, and it goes on to say here that they don't rely on the evidence that non-pertinent conversations were monitored. Rather, they rely upon the practices the agents used and supervision of the district court. They note the agents violate their own guidelines for minimization. So,
in Your Honor, that's why we're asserting that the.
Yeah, it looks like Ms. Lovin, taking a look at these two cases, Scott and Van Horn, those particular conversations would in fact be relevant. So,
The court says those particular
the minimization, the warrant requirements or the authorization from the federal court or from a superior court, as well as the minimizations and a protocol. It would seem like that's what this requires.
Okay guys, so check this out. As Cobb County prosecutors decide whether to press charges on Birdman and Young Thug for their involvement in the 2015 Lil Wayne tour bus shooting, some potentially damning evidence has surfaced. Atlanta's WSB-TV obtained a new civil court filing showing Thug made 8 calls to alleged shooter Pee Wee Roscoe, real name Jimmy Winfrey, in the 12 minutes before the incident.
In this new civil court filing we obtained, the driver's attorney points to phone records showing Young Thug called Winfrey 8 times in the moments before the shooting. They also point to this jailhouse call between Winfrey and Birdman.
You come out here and get this money. You earn money, you done blessed, you done did everything you could do, bro. It's an eye opener, bro. You know what I'm saying? On that strictly business, man.
Birdman originally denied any involvement in the shooting, but if prosecutors have their way, he and Thugger could be charged as co-conspirators. Roscoe pleaded guilty to the crime in November 2015 and was sentenced to 10 years in prison, but his conviction was eventually overturned. Prosecutors are expected to make a decision on the charges
Pee Wee long way.
against Birdman and Thug in the next 2 weeks. TMZ also reports that a source close to Birdman says the phone call was in no way referring to the bus shooting. They were also told Birdman doesn't believe Winfrey is the shooter, and he says that he would never associate with someone who tried to harm Wayne. But what do you guys think? Did Birdman and Thugger really have something?
Don't get too comfortable, all right? Ladies and gentlemen, we've had a medical issue come up with one of our participants, so I'm going to have to recess for today, okay? And these things happen. So we'll come back tomorrow morning at 9. I'd like you to be here for 9 o'clock for an anticipated 9:30 start time, and we'll just see how things go at that point in time.
So this the dude that stabbed Shannon while he was in jail.
and we'll take the week as it comes. So as is my custom, just remember your ad nauseam admonitions. Remember the things that I have told you that make this, that you're continuing to do, will make this a fair trial, a just trial, and a lawful trial as to all sides. So, do you have any other questions of me at this time? Okay, we're still on the same schedule. I'll give you a couple of days, and we'll see what today, or tomorrow, I should say, leads us, and then we'll make plans accordingly. So, with that, ladies and gentlemen, unless you have any other questions of me or any other inquiry of me, I'll see you tomorrow morning for 9 o'clock, and then we'll see if we can get started. Okay? Yes, sir. Okay. All right. All rise for our jury.
Cobbin, who shot up tour buses belonging to rapper Lil Wayne, pleaded guilty and accepted a 10-year prison sentence. He had until today to take a deal. Channel 2's Cobb County Bureau Chief Ross Gavitt live outside the courthouse with why the DA's tough stance on gang cases may have persuaded the gunman to take the deal. Man known on the streets as Pee Wee or Roscoe will spend 10 years in prison. The district attorney here in Cobb County believes the gang problem is getting out of control in Cobb and really the metro. We told you about a case last week in which his office asked the judge for a 350-year sentence in another gang case. So it's likely.
Damn, Pee Wee Longway was charged in a RICO too? What?
Jimmy Winfrey saw the writing on the wall.
I think it was best for the client to do this and avoid the massive risk if he would lose even on a single count in this case.
Manny Aurora believes his client, Jimmy Winfrey, could have beaten most of the 27 charges in the indictment, but the prosecutorial mood against gangs and gang members in Cobb County is tough.
Anytime you say the word gang and there's an African-American individual, prejudices rear their ugly head, and that's just the reality of the way it is.
Winfrey will spend 10 years in prison for the April incident on I-285, where two buses belonging to the entourage for rapper Lil Wayne came under gunfire. Prosecutors say a simmering rap feud and gang tensions led to it. They believe they could pin Winfrey as the gunman. He was indicted on 27 counts, including a rarely, if ever, used charge that references domestic terrorism. The charges Winfrey pled to are gang-related counts. DA Vic Reynolds making no apology for his take-no-prisoners approach to gang charges.
If you come to Cobb County, you shoot at a bus. Thankfully, no one was hurt, but this gentleman shot.
Appreciate the super sticker, Jerome Street. Y'all show Jerome Street some love. Hit him with some slime emojis, some slime brellas, some JS. Show him some love.
At a bus over some beef that started in Atlanta. We're not going to tolerate that.
Either you concede the time of day on a 10-year sentence, or you're going to be serving 200, 300, 400 years, as the DA has professed publicly that he would ask on every single gang case.
His testimony relies on assumptions about the strength of a signal given from a given cell tower. Any challenges to those assumptions go to the weight of his testimony, not its reliability. Indeed, numerous other courts have concluded that the mere existence of factors affecting cell signal strength that the expert may not have taken into account goes to the weight of the expert's testimony and is properly the subject of cross-examination, but does not render the fundamental methodology of cell site analysis unreliable. So, Your Honor, we would ask that this court qualify Investigator Worrell as an expert.
I am good. Yes. Before the court makes the ruling, I would like to make my argument first, please. I gave everyone an opportunity, Mr. Hoover. When I stood up and raised my hand, you went to Mr. Roosevelt. You didn't.
Hey, now, I don't know if y'all seen him, Mr. Hoover right here, Attorney Hoover. We played him a little bit before, but he would have been a good one in the trial, too. I would have liked to see him defending one of the clients, because he a good attorney right here.
Just for the record, it'll be quick, it'll be simple, but I have to make the record clear. Are you going to make any other objection that hasn't been made already? I'm going to clarify. Are the five or six areas that we've gone through already? I want to clarify what my esteemed colleagues have said. Yes, for the record, I want to clarify because I see where this is going. And moving forward, not only with this expert, but the experts we've already dealt with, the experts moving forward, I just want to clarify the record of what. Go ahead. Go ahead. Your Honor, the issue that I have is there are two different ways, because you're the gatekeeper, that you need to look at this. Number one is the validity of the methodology. We're not arguing that at all. Validity is applied is the issue that we all have. And all we're saying is this witness simply said he's testified this many times, he's done this for this many years, and that makes him an expert. We're not arguing that the methodology itself has a problem. The way he applies it is. Your Honor, in my 10 years of being a defense attorney, I've never gone to trial with a client and that client being convicted of a murder. Because I've done it for 10 years, does that make me an expert in murder trials? No. What we're talking about is this witness simply says he can't tell you what these cell sites are doing. He can't tell you what the cell companies are doing. All he does, he gets the information and he interprets it. Just because he's done it for however many years or how many times,
Remember, we can tell you that it's offered for a particularized reason that the finder of fact is free to disagree or to agree with.
That's true.
Okay, and the case law is pretty clear. I mean, in terms of what the purpose of cell records can be, or records of this nature can be utilized for. So what's your specific other objection?
Simply because he's done it for so long, we can't tell the validity as applied to what he's done. He's actually done it correctly. He even told you there's no error rate. So at the point where he's supposed to give the jury information
Well, that depends on this. Remember, that depends on the area of analysis. For example, if you're doing hard science like physics, chemistry, math, there's an error rate or other things that you can calculate.
True.
Okay, that's different than this type of science.
No, I don't agree.
So you have to look at each category that's being offered as to under Daubert as to the gatekeeping function.
True, but at the point where this witness can't tell you that the way he is applying the methodology does or does not have an error rate, at the point where this witness can't tell you the way he's applying the methodology that he's ever been wrong before, he cannot assist a jury if he can't tell you if he's right or wrong. All he's literally doing is reading a PowerPoint or reading an Excel sheet that comes from a company. All of us can do that.
I think it's more than that.
And that's why I said the argument is the validity as applied to this witness.
Hey, what up, Miss Dee? I see you. Appreciate you joining.
That's the argument that my colleagues are making. That's the argument that I just want to make clear on the record. The state has never shown you anything where he can tell you that all of his experience tells you that he's done it correctly in the past, and that's why he can do it correctly now to assist the jury in anything.
Hey, real quick, Miss Dee, you not my mom, are you? My mom call herself Dee too. Is you my mom, low key?
At this point, he can read an Excel spreadsheet, which every single other person in this room can do, so he should not be qualified as an expert for that reason. If they can go back in the past and say he's done it 700 other times or has all this experience, and we can prove that he's doing it correctly then, and we can prove he's doing it correctly now, and we can prove that he can show the jury something that the jury can't understand on their own, then he should be an expert. But this is a validity as applied argument. He cannot show you that. I'm not an expert in murder trials. I'm not. He's not an expert in whatever the state is doing because he can't tell you when he's been right, when he's been wrong, and he can't assist the jury in anything other than reading an Excel spreadsheet. That's the only argument I want to make.
All right. Based upon the arguments I've heard thus far, I'm going to qualify Mr. Wall as an expert in CSLI and historical cell data, cell site information. All right.
Your Honor, if I could make a correction.
I know, Charles Dickey, I was just joking with the Pee Wee Longway, but you heard Pee Wee Longway got locked up recently? I don't have to look into that.
For the record?
Yes, sir.
In regards to my training, the total amount of post-training was 2,000 hours. I believe it was said that my training pertaining to this was beyond 350 hours. It is not. I don't know the specifics, but I just would like to make that clear.
Well, that's an issue that you can cross-examine him at trial on, okay? Okay, all right. And may Mr. Wall be permanently temporarily excused for the time being?
Absolutely, Your Honor.
All right, Mr. Wall, I'm going to permanently excuse you as a witness for the time being. The state will call you, or the defense will call you at a particularized time. Just to make sure that they know your dates of availability, and we'll talk with you later. Okay, don't discuss your testimony until second chance in space, all right?
Yes, sir. Thank you.
Thank you, sir.
I do.
You may lower your hand. You can see, sir. Watch yourself. For the record, please state your name, spell your first and last, for the court and confirmation. Speak to the mic.
First name is John, that's John. Pulisic, that's P as in Paul, Aulisick. I'm currently in private practice, serving as an examiner of question documents.
So just anyone who wants something analyzed?
Yes, but our policy in our practice is that we only accept cases where an attorney.
Y'all heard that? Somebody phone called him a bitch or something. Hey, hold on. Let me run this back. Hold on. What was that? In the chat love in the chat looks super good. Appreciate everybody in here showing love, being respectful, family. Please don't be disrespecting nobody else chat or nobody from any other chats or whatever in my chat. You know what I'm saying? It's a love and peaceful environment. So please keep it peaceful in my chat just for future reference. Much love to y'all all. Appreciate y'all, family. Hit the like, hit the subscribe, tap in and share with a friend.
Is involved. That's basically due to confidentiality in our practice is that we only accept cases where an attorney is involved. That's basically due to confidentiality issues.
Your Honor, at this point, I would like to show the witness.
When was the last time that you were qualified as an expert in the field that you've been tendered in?
I'm not sure of the date, sir, but it would have been a deposition where I worked a civil case.
Okay.
It would be within the last 6 months.
Okay. And that was, you were qualified as an expert for purposes of a deposition?
Yes, sir.
When was the last time that you were qualified as an expert in a court, whether federal or state?
I wouldn't know the exact date, sir, but it would definitely be within the last year, and it would have been in the state of Georgia.
Okay, thank you.
Courtroom.
All right. State court, either Superior or state in Georgia?
Yes.
All right. I wanted to ask you some very specific questions about, and just from a starting point, I think the last question, maybe the second to last question you were asked by the state was whether or not you were asked to review and analyze a particular document or documents in this case.
Yes, sir. Yes, sir. I received 2 submissions relating to the same subject.
Okay. The subject would have been Jeffrey Williams.
Correct.
All right. When did you receive?
Miss Dee Dee said, laugh out loud. No, but the Young Bucks call me auntie. All right, all right. Just checking, just checking. You know, I couldn't see a picture, so I wasn't sure if you was creeping in. But appreciate you joining. I'm glad you enjoy the content.
Received those submissions?
If I could refer to my notes, Your Honor.
Please do.
You can.
With the court's permission.
You can, sir.
Okay, the first submission that I received was June 28 of 2022. And the second submission was received December 9th of 2022.
Okay. First submission in June of this year. Second submission in December of this year, maybe about a week and a half ago.
You would?
Does that sound about right?
Multiple
times. Again, as a starting point, you use the method, the methodology that you referenced earlier in analyzing these documents that were submitted to you?
Yes, sir.
Your ultimate conclusion, to use your scale, I'm going to use that word, is that you made a determination that Jeffrey Williams, quote, probably prepared the documents that was
Much love, Steph J.K.
submitted by you, to you, correct?
Yes, sir. That was part of the report dealing with the first submission that I received. The second submission that I received consisted of 3 documents that were originally provided in the first submission. So the second examination of the second submission, the results were the same as the first because the documents were obtained by me with the first submission.
Okay. Now, in regards to the documents that were submitted and your methodology, am I correct that you indicated in the testing of these documents that your ability to make any sort of definite determination was limited? Is that true?
Yes, I reached a lesser than full identification.
All right, make sure results of this makes there.
And proponents may establish an expert's qualification in many ways, including scientific training, education, experience in a particular field, but there's no mechanical checklist for measuring whether an expert is qualified to offer in any particular field. When assessing the reliability of methodology expert employees, the court considers the methodology, testability, error rate, Mr. Man, and peer review and publication and general acceptance. I'm not bound by that, but I look at those factors.
Yes, sir, and that's my point exactly, Judge. Dalbert does in fact say, in citing to United States versus Smith, 869 F. 2nd 348, 1989 case, Dalbert does in fact instruct the court that, quote, additionally, in the case of a particular scientific technique, the court ordinarily should consider the known or potential rate of error. I'm not suggesting that that is
one for the particular field.
Yes, sir.
Okay.
And that is what the witness has testified to, and he's testified under direct about error rate. And so my inquiry goes to whether or not there is a difference in expected or anticipated or known error rate when a particular conclusion is reached, as in this case, where the determination is probably prepared by the same person as opposed to definitely.
Yeah, but that's different. That's QD. That's question document examiner language. That goes. And that does not. I disagree with you, sir. The court is from question document examiners, and Mr. Pulsick has told you that these particular types of terms are terms that he uses in his profession or trade. They go along with him being able to reach a conclusion, which you can test. So, and yeah, it'll go to weight versus sufficiency. Now, Mr. Pulsick, are these maybe I'll just clarify that before I let you answer the question. Ask me any questions. Mr. Pulsick, are the explanations you gave as to the types of conclusions that you give, are they standardized in the industry or the scientific field of handwriting or question document examiners?
Yes, Your Honor.
Okay. All right. So, he's testifying about what QD question document examiners utilize in terms of their particular trade of responses. So, those are acceptable. You're going to have to ask him at trial about those, or you can kind of wrap it up in terms of this, but that's what he's testifying about.
Thank you, Judge. And if the court's position is that I cannot ask that specific question I was going to ask about.
Well, go ahead. But I'm telling you right now, I'm trying to get it while you're asking that question, okay? And I want you to...
Yeah, I remember that laugh.
I want to make sure, because neither one of you brought out, that is the language of a question document examiner. They utilize this, and I just want to make sure I didn't put words in his mouth or say something that hasn't been kind of brought out before. But that is that question document examiners, when they testify, this is the language they'll give you, and it has a certain meaning. If you want to, so you can continue at this point.
Yeah, and I'll ask just so I can.
Kristen Covey, what up, family? Appreciate you joining.
I think the answer to that question would give the court additional factors to consider in regards to the methodology. And so, Mr. Pulsick, do you remember where we were in terms of what I was asking you? I was asking about error rate. And in this particular case, your determination was that this document was probably prepared by Jeffrey Williams. Right? And my question then is there a different analysis for error rate when you reach that conclusion versus when you reach a more certified conclusion of definitely prepared by the same person? You understand the question?
Partially.
Okay.
The error rate does not pertain to the terminology that I utilize in my results of an examination.
What up, OG Cappy? What you was trying to post? You make content? I could give you a wrench if you want it, so you could post your link.
In addition, while I worked in the FBI laboratory, we were extremely conservative in our conclusions. In other words, in my degree of certitude.
That's a fact. The D-Life's Jenny D. What up, family? Appreciate you. Yeah, that's Shannon and Yak. Yeah, hope the best for them, man. Freedom boys.
Is defined by my terms.
But it's gonna be hard. It's gonna be hard for the state to win the case with Thug gone. But except that he did take the plea, so that don't look so good for them, though.
Have been codified by the agencies which I previously testified to, the FBI laboratory, ASTM, and SWIGDOT.
Gorf Love, what up? Appreciate you joining, family.
These terms are utilized and codified in written publications by not only those agencies, but also by other forensic laboratories.
In regards to this particular analysis, you testified previously that these results, both the ones from June of this year and the one from December of this year, were not peer-reviewed. Is that correct?
FFS, drop your OF link in the chat. You said he make OnlyFans content. Drop the link in the chat so they can go sub up.
I think you testified to that previously, is that right?
Correct.
Can you explain to the court why they were not? If the object is accuracy, why were they not peer-reviewed, given your previous testimony about the necessity or the importance of peer review, certainly while you were at FBI?
Well, my conclusions, specifically in this matter, were certain in my mind as far as an examiner of 30 years. I would have...
Shout out to Becky. She said, if your mom is still living, give her a message for me, please. She did a fine job with you. You are the most polite and grateful content creator. I know. Appreciate that, family.
If I was not able to reach a conclusion, I would have utilized the middle term of my continuum, as I cannot determine one way or the other whether or not an individual writer prepared a question document.
When was the last time that any of your work was peer reviewed?
It would be within the last year, but I'm not certain as to a date. What I routinely do is, if I am uncertain as to
Steph JK said, I'm hanging. Put some respect on my name. I ain't going to bed.
my findings, I will ask my partner to review the evidence that I've received, and I will provide my partner with the submitted documents without giving what results I've reached in that matter. The peer review would be strictly done by my partner, all alone by herself.
All right. But that was not done here?
No, sir.
In regards to the accuracy of your conclusions, is it true that you indicated that your initial analysis was done based on photocopies of documents?
Correct.
Was your second analysis, the one done in December, were those done from original documents?
No, sir.
Okay. So they're both done from, those analyses were both done from documents with photocopies of signatures or writings, is that right?
Correct.
And if I heard you correctly, the accuracy or your ability to make a definite determination is going to be limited based on analysis of photocopy documents.
That's correct. A photocopy or machine-generated document is a two-dimensional document, whereas a original document is a three-dimensional document, which lends itself to additional exams, such as writing pressure involved, the writing ink that may be involved. So the limitation, excuse me, the limitation of the machine copies or photocopies somewhat limits the possibility of a positive association. However, I have associated machine copies or photocopies in previous cases, and either definitely identified or associated with a writer or eliminated a writer. It is possible.
All right. Thanks, sir. Those are all the questions I have.
Anybody else?
I have a couple questions. I'm Sean from Since you've been in private practice, how many sufficiency tests have you taken?
While in private practice?
Yes.
None.
Okay. So there are no mandatory peer reviews now that you're no longer with the feds, now that you're in private practice, and you don't.
Here you go again. Watch, check him out. My boy be getting it. I just dropped the link to Reggie Righteous' new video. Y'all go and check that out. Fire little visualizer, fire song. Y'all show some love. Get his subs up. Get his views up. Appreciate that, family.
Take any more proficiency tests.
Correct. I'll drop it in there.
So this methodology that you're using, it's subjective, correct?
No, it's codified, and all forensic document examiners follow the same protocols and methodology.
Well, let me put it like this. You, as an examiner, can notice something that gets you to a resolution, right? That's what you do. You notice certain things in handwriting that gets you to the conclusion of this person wrote it, this person didn't write it, or in between, correct?
Correct.
Another examiner, not your partner, not in your office, just another examiner, can get to the same conclusion, but noting different things in the handwriting. Is that correct?
I wouldn't be able to determine whether or not they were not utilizing the same samples that I did. A qualified examiner would receive the same documents that I received and would observe the same characteristics that are utilized by qualified examiners.
Sure. But you don't know if the other examiner noted every single thing that you did to get to the conclusion.
Mr. Hoover, that's kind of misleading because he's testified if he doesn't feel comfortable with it, then he submits it to another examiner. You're asking the other question.
And why Glanville always doing all the arguments? I just dropped Kat Knott Williams' link in the chat once again for those who don't know about her. Show her some love. Great content creator.
Yeah, the converse of that.
Well, then let me rephrase. I apologize.
Okay, all right.
If you only peer review it when you don't feel comfortable and you don't take proficiency tests and you're basing it off of what you believe is true, how do you ever know you're wrong?
Steph JK says, stop playing, put some respect on my name. I never said I was leaving. I said I was motherfucking tired.
You what?
Motherfucking tired.
What?
I'm motherfucking tired.
Well, I'd be unable to determine if I was in error. it's still my expert opinion. And the opinion in most courtroom situations, I would prepare a demonstrative chart outlining characteristics that I observed or did not observe, so that the jury or the judge would be able to look at that chart, demonstrative chart, and observe the same characteristics which I did during my examination.
So in that long answer, I believe you just said that you don't know if you're wrong. That's what, you don't know if you erred or not.
No, I would have no way of knowing if I was wrong.
No further question, Your Honor.
Anybody else? Okay, all right. Any argument?
Yes. I'm going to ask the court not to qualify this witness as a certified document examiner or whatever was proffered by the state. I understand Albert, I understand 702. As my esteemed co-defendant's counsel has stated previously, methodology is important.
Yeah, no one. You could drop a link.
Protocols are important, but the application of that methodology in this particular instance is what the court should consider in regards to whether or not this person is qualified as an expert. And what I got to keep harping on is we start from a standpoint that this was not a certified resolution. He did not come to a conclusion that this was definitely this person. And so given that we start with some degree of uncertainty, saying probably is an uncertainty, given that we start there, the question that we...
Let me hijack you. I'm going to hijack you. Probably is a question document examiner's term that you can cross-examine him on. And it goes to weight and sufficiency. All question document examiners utilize the same language.
The word probably...
Okay, let's just disagree on that one, okay?
Well, that's fine, Judge.
Adam,
that is...
Given his field and trade, that is what he's testified to. It does not have the meaning that you comport it to. So, I mean, unless you've got some other methodology, I'm waiting to hear it.
Let me continue my argument then. Yes, I would start. My argument was that, given that we start from a determination that using the word proper.
Yeah, Steph J. Yeah, you can post that here, and if they don't let it go through here, send it to my my DM or my email or something. You know, I'm trying to help you get subscribers, like you trying to help me. You know, we helping each other.
The court has to take a look at whether or not the Daubert standards are met. And what Mr. Hoover said was that exactly, the question goes to the point. He is unable to determine if he is wrong. This is an analysis that was not peer-reviewed. And the witness started by talking about the importance...
Yeah, but he told you why it wasn't peer-reviewed. That goes to weight.
Well, no, he did not explain why it was not peer-reviewed.
Yes, he did. I'll tell you the answer right now. He said it's not peer-reviewed because he's comfortable with the analysis that he made.
Right, and he's comfortable with the analysis that he made, but he does not...
Given his 30 years. And then he said if he wasn't comfortable, he would get another examiner to go, usually his partner, to go ahead and do that. He didn't feel he needed to do that in this case. And when he was with the FBI, he had the mechanism of doing that.
Subjective to belief as to whether or not they are accurate or not is not... And then deciding, well, I'm not going to have a peer review because I think it's fine, is not a scientific method. A subjective belief is not a scientific method or the use of scientific methodology. I would simply, and the witness explained in detail about his time at the FBI, his 20-plus years, his time at the GBI, and the importance of peer review.
Yo, Laugh, I'm working on an episode with all of them coming up soon, so they'll be back up soon.
And why that was important. But in this case, in this particular case, where determination is made, it was not peer-reviewed. And that is certainly something that the court ought to consider as to whether or not he ought to be qualified. Not just whether or not this science is acceptable. Yes, the science is, or the methodology is acceptable. It's been acceptable in courts previously. But as applied in this particular case, are the factors that Daubert and 702 applied in this case such that he should be qualified as an expert? Well, I simply would contend that he's not met those standards. That is an extreme...
No, that's not the panel link. I'll set up a panel, though. I'll get that going pretty soon. I just haven't set it up. I mean, I could do it. I just got to prepare for it. I got to plan it out, but we'll make it happen, though. I'll schedule that up pretty soon.
Really important portion of whether or not the science should be acceptable and whether he should be qualified as an expert, I would contend that he should not be.
Okay. Thank you, sir. Mr. Hoover.
Yes, Your Honor.
Mr. Jones, I got you next, okay? All right.
So I'm going to be qualified. Not just whether or not this science is acceptable. Yes, the science is, or the methodology is acceptable. It's been acceptable in courts previously. But as applied in this particular case, are the factors that Daubert and 702 require applied in this case such that he should be qualified as an expert? Well, I simply would contend that he's not met those standards. That is an extremely important portion of whether or not the science should be acceptable and whether he should be qualified as an expert. I would contend that he should not be.
Okay. Thank you, sir. Mr. Hoover.
Yes, Your Honor.
Mr. Jones, I got you next, okay? All right.
Sean Hoover again for Antonio Sumner. And Your Honor, I have to make this clear. Regardless if we're talking about 702, regardless if we're talking about Dauber, regardless if we're talking about Kumho Tire, it all comes down to two things. Reliability in the methodology and reliability as the way this person applied it. As the gatekeeper, you have to determine that what goes to a jury is reliable. I have to disagree with what you said because the witness literally just said, I'm right because I think I'm right, but I don't know if I'm ever wrong.
That's part of the examination for you. I mean, he's testified that's the methodology, and that's in terms of how he and why he is not peer reviewed this particular issue. So I mean,
but Your Honor, the reason we go through these hearings is because the state is trying to qualify this person as an expert, which puts him above a layperson, which puts him above an officer.
I understand.
The expert is supposed to be able to apply or give information to a jury for them to understand something they can't understand. So at the point where the witness says, I don't know when I'm wrong, how does he tell or give information to a jury for them to understand anything else?
If he's wrong, which he says is not able to make a determination or a conclusion, then of course he would then at that point in time have it peer reviewed. But he's comfortable with his particular analysis, so that's why that's the explanation, and that's utilized in his field or trade of occupation.
And I think you were missing the reliability part of this. The point is, he doesn't get to go to open that door and walk through as an expert until we know that the way he did something is reliable. Simply because he says he knows it's done.
Okay, remember. This is the science of fingerprinting, or I should say, of question document examination.
Sure.
Expert threshold. All those things you're mentioning right now go to when he comes to trial and he presents the standards, when he presents against a known versus question document. All the things that you're saying are perfectly clear and can be examined.
Sure.
Don't disagree with it at this point in time, okay?
Yes. The problem is that's not 100% true. The court has to look at reliability of the methodology and reliability of the person that is applying the methodology in this case.
Testability, error rate, peer review, and publication, general acceptance. Those are the factors that I look at, okay? They're factors, okay? There's not a hard and fast rule. I know that you keep harping on this, and I understand that. You're doing your job, but I'm just telling you at this point in time, it certainly goes to my gatekeeping function, but it certainly as well goes to your ability to examine this particular witness should he be called to testify in trial.
And just to make the record clear, I object to this person being qualified as an expert under the validity as applied reliability standards that the court must consider before he becomes an expert.
I'm saying I have, and I'm telling you, I have applied that, okay? So, Mr. Jimmons, go ahead.
Good morning, Your Honor. Suli Chalakimenes, because of Mr. Dorsey, and just want to lay out my argument, and I don't mean to be repetitive. I'm just trying to keep my thoughts together. It is hard. I'm trying to.
Well, you need to bring up something new that hasn't been otherwise articulated by Mr. Adams and Mr. Hoover.
Absolutely.
Okay.
Yeah. I just want to make it. We all know that the new rules of evidence that have been applied, we've adopted in Georgia a few years ago, federal rules of evidence, they tend to lean towards admissibility. It is something.
The federal rules as a whole do.
Yes, yeah. And in Georgia, we also want the jurors to see the evidence, to hear the evidence. We want them to, if something goes to prove that a fact is more likely or less likely, then it's relevant, and we want them to hear about it and make a decision. I do want to make a distinction, Daubert and Kumho. It kind of goes the other way. That's what gatekeeper is. Gatekeepers are these young men with weapons and vests and tactical gear. They're keeping the gate from making sure that we don't get rushed by a bunch of public and silly people that are going to make phone calls.
Hey, well, if you need like some overlays or something, you know what I'm saying? Some templates or something, holla at me. I got you.
And do stupid stuff on Zoom. They're the gatekeepers because we don't want all of that because that's irrelevant. That has nothing to do with this case. And that is your role, Your Honor. Respectfully, that is your role to make sure that some of this stuff doesn't just come in because the state wants it and bolster.
Yeah, I imagine he for sure got a lot of tracks coming soon. That's for sure.
Experts have a different standard. An expert can testify as to hearsay and stuff that they haven't seen or done themselves. They can give an opinion. Why? Because they're experts and they have the experience. There is no doubt that this man is, Mr. Kosnick, I apologize, sir, is an expert. He has had the training. He has had the experience. He has had peer review. Most importantly, and the state went really into detail with this. And you know why? Because it matters. He knows the methodology. We're not talking about hard science. We're not talking about chemistry and physics. We're talking about handwriting, but you know what? I can't tell. If you show me like some scribble, I don't know if it's Mr. Williams' signature, it might be former President Trump's signature, just a bunch of squiggly lines. We need somebody like him to tell us. But here is the key. Again, I'm referencing mostly Kumo Tire versus Carmichael.
All right, Joanna, you tooled up. Drop your link in the chat so we can come check you out.
That's 526 U.S. 137, 1999 case, Supreme Court. What it said is pretty much, you know what? The Dauber standard, you can't just apply it to hard science. You're going to apply it to anything else that requires a certain level of expertise that a lay person cannot understand, because that's the key. Can you please explain to everybody else what it is that you have studied so hard for? But you have to do it right. It's like a recipe. It's like making a cake. I ain't no expert. I am not a chef. And you can give me all the ingredients. You can give me a bunch of flour and eggs and whatever. You give it to me, I don't know what to do with it. You know what I have to do? I have to follow a recipe. There is a methodology, step by step. And he has testified that there is a methodology that exists. And when he was under the supervision of the FBI, the federal government, somebody with standards and somebody wants to make sure things are done right, he followed it. Part of that was peer review. So, I just want to say that. Yes, Kumo says that scientific knowledge is not the only thing that we apply to Dauber standard.
Y'all go check out No One. He dropped his link in the chat too, I think. Drop it for him, No One.
We're also going to apply it to technical and other specialized knowledge, like this. It is flexible. Let's remember that Kumo was not about letting everything in. Kumo was actually about a case about the expert that the plaintiffs wanted to put up and say that he knew why the tire exploded, because either this...
Joanna just dropped her link. Y'all go sub up, hit the like, check her content out. I haven't got a chance to see it, but I'll definitely be checking it out. Appreciate you, family.
Happened, and if that didn't happen, there's a manufacturer error. And you know what? The defendants were able to get that suppressed because he didn't apply the science correctly. He didn't do what he said can be done. And then, they went up to the Court of Appeals and Supreme Court were saying, no, you can't use the Dauber standard on him because he's not a scientist. Supreme Court just said yes, and the discretion is the discretion for the court not to let it in. Not discretion for let's just let everything in and let a jury determine as to weight and admissibility. No, we want the jury to not waste its time with all these fancy titles.
But you'd agree that handwriting has been around 100 years.
Absolutely.
So is there any, how would you address that?
Handwriting's been around 100 years.
And question document examination of handwriting.
And it was not, the methodology that he knows was not applied in this case. And a lot of the other experts, I'm just going to make my argument now because I don't want to have to keep standing up with the same exact point. You have to apply.
Do so.
You have to apply the methodology that you claim it is. Some things don't have a methodology. Some things you just know how to do, and you use certain tools, or you have the education, but they're just not a recipe. But in this case, he testified there is, and he testified he chose not to use it. Because one of those things, as he had said, why, Mr. Adams asked, why peer review? To ensure results are accurate and done. Protocol. What is protocol? You have to follow the steps. You have to follow the recipe. Why do we have protocols? Why do we get up and accuse police officers of violating people's civil rights because they didn't follow the standard operating procedures? The protocols. Follow your protocols. Follow your own rules. Follow the rules of the science that you should be respecting. That you know they exist for a reason. They're not just there to CYA. No, they exist there because you want to make sure it's done right. Whether it's for the government or for the defense or for some tire company, you want to make sure it's done right. So, and I'm sorry, again, I'm trying to keep up with my notes, but no desk makes it a little difficult, so
you can.
My apologies.
All right.
I just want to emphasize, Robert, it establishes a standard of evidence reliability which requires a valid connection to the
And B's on Mars. Why is Glanville arguing anyway? Ain't the state supposed to be the one arguing? Why the hell is he up here arguing with Glanville, with the judge? Ain't he supposed to be the referee?
Inquiry as a precondition.
This whole time, you ain't heard him say once, state, do you have anything to say? You want to say anything, state? Nah, he making the argument. They just chilling. They over there watching Miss D. Williams OnlyFans.
To admissibility. We are trying to determine not whether or not the science exists, not whether or not he's an expert at the science, but did he follow the steps properly as a precondition to letting the jury hear from him as an expert. That's my entire point, Your Honor. You can do whatever you can talk about any sciences you want. You can bring in all the experts you want, but just make sure they do it right before we do all of this dance in front of the jury that's just going to be confused if you didn't do it right. Yes, it goes to weight and admissibility, but it also goes to the gatekeeping. Don't let the jury hear stuff that was done improperly. Let them hear the good science. Let them hear about the proper experts that follow their methods. Don't let them just hear about anybody just because they're an expert. It's not a question as to is he an expert. It's a question about if he applied his expertise properly to this case. And my last point, Your Honor, I think it's not part of the order, but late Justice Scalia, which always is the sense.
FFS, send me the link.
Are always very on point. I think it is worth adding, it is not discretion to perform the function of, well, it's inadequately, I'm sorry, I apologize. I think it is worth adding that it is not discretion to perform the function.
Happy Halloween, family.
Inadequately. Rather, it is the discretion to choose among reasonable means of excluding expertise that is false and science that is junky. But if there is a science, let's use it. If there is a recipe, follow the recipe. Don't just throw everything in the blender and then toss it in the oven and hoping that you're going to get a 3-layer cake with beautiful and tasty results. Because that just doesn't happen. You have to follow the steps, Your Honor. Thank you.
All right. Ms. Rosenwasser?
Anybody else?
I think you're good.
I got more.
You're kind of inadequate now that he made a cake analogy, right? Yeah, you feel bad about that, don't you? Okay.
What up, Charlie Hager? I see you. Happy Halloween, family. What up, Shanna P. Law Nerd? Shanna P. the Law Nerd. What up, family? I see you. Appreciate you joining.
All right. Okay. For purposes of, she has not put that on record for purposes of posterities, but she's ready to do that this time. Okay.
We're ready to mic on.
Okay.
We're ready to mic on.
Yoda. He got the Yoda ears.
Ready, Your Honor?
Yes, ma'am. Go right ahead.
Your Honor.
Hey, who was that saying free YOUNGTHUG? We got YOUNGTHUG coming up too. His first plea deal.
As it relates to Mr. Tanquarius Mender, Mr. Mender is charged with count 1 of the indictment, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. He's also charged with count 44 of the.
Oh yeah, I think that was Bahira. Bahira, you still here? You still rocking with us?
Indictment, which is possession of a weapon by an incarcerated individual, which carries a sentence of 1 to 5 years. Count 45, possession of a telecommunication device by an incarcerated individual, which carries a sentence of 1 to 5 years. And last, count 46, which is participation in criminal street gang activity, which carries a sentence of 5 to 20 years. Mr. Mender is an ANC recidivist. The state did file a recidivist notice on December 9th of this year. If Mr. Mender was found guilty of all the counts in the indictment, he'd be looking at a maximum exposure of 50 years to serve in prison.
Hey, what up, cousin? Welcome to the family. Y'all go and show Joanna some love.
And now, could you explain the difference, I think, for Ms. I'm sure that Ms. Fagan has probably explained that to her client, but can you tell Mr., for the benefit of the record and for Mr. Mender's benefit, what potentially may happen if he were to be convicted of any of these particular counts? Like what would, under A or C?
Yes, if he's convicted of any of the counts, as an ANC recidivist, Mr. Mender, you would have to get the maximum amount on for that charge, and then whatever time the court gives you, which if it was to be the maximum, you have to spend every day door to door, which means you have to spend every day in custody.
He had no good time.
No.
It's a to-the-door sentence.
Yes, he would get any.
Well, hold on now. We make clothes too now. Hold on. We make clothes too. You can't be taking my business now. No, I'm messing with you.
Credit for a time served.
Of course, yeah, absolutely.
But anything else would be a full sentence door to door.
So his max is 50 years?
Yes, Your Honor.
Okay, and what's the state's offer?
Yes, Your Honor. The state's offer for Mr. Mender as to count 1 is 16 years to serve 1 year, commuted to time served, with a balance of 15 years on probation. The state would offer that his probation could be terminated upon successful completion of the first 10 years of this sentence, provided that he violated no provisions of the agreement or no special conditions of the agreement, and that he violates no law of the state of Georgia. As to count 44, the state's recommendation is 5 years to serve 1 year, commuted to time served, with a balance to be served on probation, concurrent with count 1. As to count 45, it would be 5 years to serve 1 year, commuted to time served in confinement.
Y'all also go check out her Instagram.
Commute to time served, followed by 4 years on probation, concurrent with counts 1 and 44. And count 46 would be 16 years to serve 1 year, commute to time served, followed by 15 years on probation, concurrent with count 1, 44, and 45. Would be the offer. Mr. Mender also is currently on another indictment.
Show some love, drop some slime umbrellas for Joanna. Thanks, cuzzo. I drop my Insta and my YouTube channel. Everything I make is personalized. Yep, appreciate you, family. We do the same thing here, too. I also make dominoes, clothing, t-shirts, water bottles, cups. I need to promote more. I'll be slipping. But appreciate it. You know, y'all go show Joanna some love.
21 SC 178250. In this case, as a part of the agreement, would run concurrent with that case whenever he resolved that other case, Your Honor.
Is that before me or before another division?
It is in this division currently, Your Honor, and that's being handled by ADA Lauren Jansen with the state.
Does he have bond on that case ending in 250?
I don't believe he has a bond on that case. No, he has a no bond status.
But on this case, he could go home today.
Correct. If he was given a bond, he would. This case, he would not have served any jail time on this case.
Okay.
And that offer will also conclude today, Your Honor.
All right. Ms. Fagan, have you communicated that to your client in terms of is that to correctly summarize the plea agreement or the potential plea offer, I should say?
The only change was that he wasn't aware of the concurrent status for the second case. At this time, though, he still maintains a not guilty plea.
Sure.
Respectfully rejects the offer, and we announce ready for trial.
Okay, Mr. Mender, I'll tell you and I'll tell Mr. Beatty and Mr. Stevens the same thing, okay? At this point, you have the absolute right to plead not guilty, and that's what the law will presume, and the court will, of course, instruct that you have a presumption, as the presumptions and protections you enjoy as a criminal accused. You have to decide for yourselves what you want to do in this particular case, depending upon the results or the outcome of the trial. The only thing I would tell you, Mr. Mender, is the most, and I'm sure that Ms. Fagan, she's a very fine attorney. Seen her work. But trials, there's one thing about trials, it's uncertainty. You don't know what's going to happen. So you got to beat 4 counts. And if you don't beat them, what will happen is, under this A&C recidivist statute, I have to, under the law, sentence you to the maximum sentence. And then whatever I sentence you to, you serve to the door. That's not anything I have any discretion over. It's not anything because I don't like you or because of what you're being charged with or whatever. Those have nothing to do with anything. That's what the state of Georgia, the legislature has mandated that I sentence you to. So one of the things a plea does is you know what you're getting. It caps your exposure. So, and what the state's telling you today is if you take the plea today, this is what you're going to get, and this is what I probably sentence you to.
Them Yoda ears.
And you're done. You got to decide that for yourself. You can't be worried about any of these other folks that are attached to this indictment, because a plea is individual to that particular person for those particular reasons that he or she he or she feels is of best interest to them, not anybody else. So if you want a couple minutes out to talk with Ms. Fagan about that, nobody will be the wiser, and certainly, but if you don't wish to do so, that's fine too. You'll get the fairest trial that the law demands and expects you to get. You will get that. I, as your trial judge, will make sure that that occurs. But one of the things...
Look, he trying to make sure he trying to get him to plead like he fighting for it.
Things I cannot do is I can't force the state at the end of trial to pull this recidivist notice. If you get convicted, they can maintain it, and you'll serve every day of it. And Ms. Fagan can ask them to pull it, and they can say no. I can't make them do that. So you've got a lot to think about. So I'll give you a few more minutes to ponder that, because that is, when they file a recidivist notice, they have basically, in poker terms, they've called. Like, what do you want to do? So I'll let you think about that, and you can let me know, and if not, then we'll see you next week for trial. Mr. Beatty, where are you?
Here, y'all. Judge, we're in a similar situation. We would reject the state's offer as provided on record, Your Honor. However, Mr. Beebe would ask the court if the court would hear a non-negotiated plea as to the indictment.
I would.
If that's the case, Judge, Mr. Beebe would then ask if he does not agree with Your Honor's sentence, would the court allow him to withdraw the plea and proceed to trial?
I need to think about it.
I got you, Laugh. I'll come and tap in with you, family.
That for just a second, okay?
Understood.
Just give me a minute, okay? But yes, that's more than fine. Mr. Beebe, you got the same kind of same discussion I had with Mr. Mr. Mender applies to you, but let me just get back with you in just a second, okay? Mr. Stevens, where are you?
I'm here, Judge.
Okay, madam, are you still talking with your client?
Yes, Your Honor, I'm actually still exchanging text messages with the state. So
Okay, I'm going to take a couple of minutes out and let you all continue to chat. I'm going to just take a recess, and I'll come back in just a minute, okay?
Thank you, Your Honor.
Okay, you're very welcome. All right.
Whoops, that wasn't supposed to be on there. I think YOUNGTHUG coming up next. Yep, this the YOUNGTHUG
Yes, Your Honor, there was
plea
one,
deal.
Correction I wanted to make. I believe that the plea agreement, that is State's Exhibit 1AS, said that if the defendant violates any term of this agreement, he would be subject to service up to 35 years in prison, and that should be 30 as opposed to 35 years.
Okay.
Your Honor, what the state recommends is that at this time the defendant be sentenced to 15 years of probation on count 30 to run consecutively with count 1, and provided the defendant complies with the plea agreement as contained in the negotiated portion of the sentence section 2B, upon the initial or the completion of the initial trial of this case, the state shall pose no objection to the defendant, to any motion on behalf of the defendant.
I make all my stuff custom though. That's why I usually don't post that much. I make everything custom per order. So whatever you want, let me know and I'll make it and we make it happen. One of ones.
To withdraw that guilty plea, and the state agrees to no pros count 30.
All right, okay. Mr. Wright?
Your Honor, briefly.
Anything on behalf of Mr. Sledge?
Your Honor, my client is 41 years of age. He has 8 children. 3 are grown. So that would leave 5 minor children. He actually has 3 brothers that are alive, 1 deceased. His father is deceased, but his mom is still with us. He is very anxious to be able to get back to his family. His outlook on this is silly, childish things done in the past as a younger man have sort of come to bite him, and he has grown, I think, grown out of some of those, as we say, childish things. So he is asking this court respectfully to agree and accept this, the terms of this agreement, and sentence him according to the terms of this agreement. He will abide to each and every provision that this agreement provides, whether it's through testimony or otherwise. And again, he is thankful to have this opportunity to get back to his family, to his children, and to the remainder of his life. You will not see him after this trial and all this is over. You will not see him again. Thank you very much, Judge.
Okay.
And the state has one other addition. With respect to count 30, the state has no objection to this court suspending that 15 years with the same provisions that we've listed for the court previously. And additionally, the state, in accordance with the state's representation to Mr. Wright prior to this moment, the state would have no objection.
What's a Annie Abd or Annie Abd? Annie ABT. What's that? Shout out to Shauna. Appreciate you, family.
To after the defendant's successful completion of the first 10 years of this probation, of it being terminated.
Okay. All right. Mr. Wright, anything else?
No, Your Honor.
Okay. Mr. Sledge, again, good afternoon, sir.
How you doing, Your Honor?
I'm fine. Sir, did you have the opportunity to fully discuss the facts and circumstances of this case with your attorney, Mr. Wright, to your satisfaction?
Yes, Your Honor.
Did he explain to you the various constitutional rights you give up by pleading guilty to your satisfaction? Those are the same rights that my prosecutor, Ms. Love, just set forth on the record a few minutes ago. Do you have any questions about those rights you wish to ask me?
No, Your Honor.
All right. I'm holding the indictment in this case, and on page 6, above the word defendant, is this your name, or is this your signature?
Yes, Your Honor.
On the face of this indictment?
Yes, Your Honor.
Okay. Before you sign this indictment, did you have an opportunity to fully discuss the facts and circumstances of this case
Mookie, welcome back, family.
with your attorney, Mr. Wright, to your satisfaction?
Yes, Your Honor.
All right. Is there anything else in this indictment that you wish to ask me?
No, Your Honor.
All right. I'll note the indictment's been signed and the plea has been entered. Mr. Sledge, based upon the responses that you've given during the court's inquiry, I find that your guilty plea is freely and voluntarily entered. I find a factual basis for your plea. I'm going to accept your plea as tendered and as negotiated. To count 1, conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, this court will sentence you to 15 years to serve on probation. As it pertains to you in count 30, possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm.
Yo, no one. Do you make the beats too, or do you be using other people's beats?
OCGA 16-11-133. This court will sentence you to 15 years probation consecutive to count 1.
Yeah, I never really check my email. I only check my email when somebody tell me they email me. I got so many emails. I be on different accounts doing different stuff for my other business. But yeah, I do need to get better with that. Appreciate you, family.
Now, the state is also indicating, your attorney has also indicated that
upon the initial trial of the case, provided you comply with the special conditions as outlined in sections B, C, D, F, and I of section 3, that you should be able to withdraw your guilty plea in terms of that count, and the state will null process that count. Okay?
Yes, Your Honor.
All right. You also agree that you'll abide by each and all the terms of the negotiated agreement, is that correct?
Yes, Your Honor.
If you fail to abide by any term of this agreement, it could constitute a violation of this agreement.
Yes, Your Honor.
You shall testify truthfully about all matters related to this case, upon which you're questioned in any trial or judicial proceeding stemming from the facts in this indictment. Is that correct?
Yes, Your Honor.
In accordance with testifying truthfully, you acknowledge each and all of the statements contained in the defendant's factual acknowledgement section of this agreement are true. Is that correct?
Yes, Your Honor.
And you agree that you'll testify truthfully about each statement contained within the defendant's factual acknowledgments, right?
Yes, Your Honor.
You shall possess no guns unless your right to do so is restored.
Yes, Your Honor.
You shall commit no criminal acts, right?
Yes, Your Honor.
And you shall submit to random drug screens as designated by the Department of Community Supervision or any agency designated by the court in this case. You understand that?
Yes, Your Honor.
If you test positive for any Schedule 1, 2, or 3 drug, within 30 days of that positive test, you'll undergo drug rehabilitation as designated by the court or the Department of Community Supervision, and you have to successfully complete that, right?
Yes, Your Honor.
And you relinquish any Fifth Amendment right relating to any statement contained within the defendant's factual acknowledgments of this plea agreement.
Yes, Your Honor.
You also agree to abide by a curfew from 10 p.m. to 6 a.m. unless you're otherwise working, in school, or an emergency arises.
Yes, Your Honor.
So that means if you work the second shift or the third shift, as long as you let probation know, it wouldn't be a violation of your probation. You understand that?
Yes, Your Honor.
You also understand, I understand you have minors, so you got to take your kid to a doc in a box, or you have something to check on your mother or whatever else. That won't violate your probation, but if they catch you someplace you're not supposed to be, you'll be back having a very uncomfortable conversation with me.
Yes, Your Honor.
Okay. And then you can't have any contact with any co-defendants on this indictment except through attorneys, okay?
Yes, Your Honor.
Do you have any questions about your sentence, sir?
No, Your Honor.
Steph JK said, let me upgrade you. Stepped up to the bronze, fam. Appreciate you, family. Appreciate the love. Y'all drop some slime umbrellas for Steph JK and some ice cream emojis.
Mr. Wright or Ms. Love, any clarifications on the court entry sentence?
What the hell happened? How'd that get mixed up together?
Or defense entry plea?
Well, if you could, just say your name and spell it for us, just in case anyone else is going to do it.
Okay. Then that will be the sentence of the court. Mr. Chamberlain, anything? Okay. All right. Good luck to you, sir, okay?
All right.
So walk us through what you think of this plea deal you were able to negotiate.
Well, insofar as it resolves all of these charges against Mr. Nichols, I think it is an exceptional result. It's an exceptional result for the following reasons. No murder charges. No gang charges. No factual acknowledgments required by the state. No other charges except for one conspiracy charge that was factually underpinned by convictions that Mr. Nichols already had from almost 6 years ago. So that result, I think,
That's a fact. Miss Westmoreland looking good over there, ain't she? Looking like a snack.
is an excellent result for him. It resolves all of these cases.
Am I old? Do people still say that?
You know, the RICO charge in this case was a RICO conspiracy. And underlying the RICO conspiracy were all the 100+ factual predicates, some of which have already been resolved by and against Mr. Nichols. Some of them we hadn't even gotten to. And I don't believe the state would have been able to prove Mr. Nichols' responsibility for those predicate acts. So this was, yeah, we were in a conspiracy. Yeah, we acknowledge that factually the underpinnings of the RICO conspiracy are satisfied by what already was presented and what he had already pledged. But
and I agree that that's
nothing
what
else.
The situation is.
As we said, no murder, no guns,
able to resolve our
nothing
case
else.
without it.
Dang, I think I messed this part up on accident, family. Hold on.
There's like a complicated formula of how early in the year you can get out.
It's not that complicated. It doesn't take time.
Yeah, I accidentally must have scooted it over, but shout out to Miss Westmoreland. Looking like a snack. Appreciate y'all being here, family. Hit the like, hit the subscribe, tap in, share with a friend. We're going to have to come back to that a little later. We're going to have to come to that part later because I messed that up somehow.
Let's happen, developed a pretty sophisticated understanding of the system. I mean,
My bad,
you can
family.
Look at me when something happens and go, hey, this is what happened. This is what should happen. You know, I know what is going on here. So he, like I'm saying, he's a sponge. I mean, let's bring these kids forward.
This trial has been a learning process for all involved in YouTube and media and also in the prosecution. What are you hoping to come from?
Glanville did say dock in the box, or a dock in the box.
All of the things that you've shared and done with.
Well, let me just shout out to the YouTube folks. I mean, we all watched it. We all watched the commentary. We love the commentary, and we point out the commentary. So we've had a good time seeing the reaction to it. That it's always, inflammatory, it's flamboyant, it's this, and something always interesting has happened, except for the days and days we have with phone records. And so somebody up there saying, well, this is the phone number that's associated with, Miss Johnson. And really, what was the name of that? What's the address? And let's write that down. I mean, it's just drudgery. It is, section after section after section. And I know it's all part of a puzzle, but I hope that everybody understands that it is not all excitement and that you've seen how deeply everybody has dug into this case and all of the things that have been litigated week after week and day after day after day. So we appreciate what everybody says.
Any message to the rest of the defense attorneys still fighting for their clients in this case?
Good luck.
Do you think this plea is going to affect any of the rest of the case moving forward?
Well, you know something, I think we were lucky. Not lucky. Let me try to find a better word. We were able to resolve our case in a different fashion than what I understand has been put on the table for others.
That's a fact. I'm mad I messed her part up. That was the main part I wanted to see. Ms. Westmoreland. I'm going to have to bring that back on the next episode.
When I say we resolved it to a single count, we resolved it without those other acts. We resolved it without any factual acknowledgments. If you have been following this closely, every other person in this case who has pled has signed a plea agreement with factual acknowledgments. YSL, I'm a member, it's a gang, I did this, I
I'm looking for it. I'm typing her name in right now.
would do this on behalf of the gang, and I did this, and I agree that that's what the situation is. We were able to resolve our case without any of that, and that's the distinction. And I certainly hope, I wish the very best for everyone.
Try to censor your curse words, no one.
Of those young men, and including, Jeffrey Williams, who's been sitting in jail for years now. And he is an incredible talent and a wonderful young man. So I wish the best for all of them.
And last question from me. Do you know the 7 years? I know there's like a complicated formula of how early in theory he could
Well,
get
it's not
out.
that complicated.
Okay.
It doesn't take Einstein. Remember, E equals MC squared. Do we know that? We do know that. Do I know? No, I don't. If I knew, are you going to ask how much
I was going to say how much
Have a good one, Gorflub. Appreciate you, family.
time does he have left of the 7 years?
But he's got, what, 24 plus 5, 29 months in. There are parole guidelines for his offense, but at the end of the day, it's up to the Georgia Board of Pardons and Paroles. And if I knew that, I would be the richest lawyer in the world, and I would be on a beach with a cocktail in one of those little umbrellas, and my pinky would be up. Okay.
I think it was kind of a cliffhanger if he had any other outstanding issues that would affect any of his probation going forward. To your knowledge, well, I know that you can't go in depth, but is there anything that will...
You said shit. You could say it, but just try to censor it so YouTube don't be flagging it. Appreciate y'all, family. Hit the like, hit the subscribe, tap in, share with a friend.
Affect his...
Well, I don't know the answer to that. There is nothing related to this case. There is nothing that he has in his past that is affecting his ability to move forward and appropriately serve this case, this sentence. Okay? His kids and his wife look forward to getting him back home. Gang, and I did this, and I agree that that's what the situation is. We were able to resolve our case without any of that, and that's the distinction. And I certainly hope, I wish the very best for every one of those young men, and including, Jeffrey Williams, who's been sitting in jail for years now. And he is an incredible talent and a wonderful young man. So I wish the best for him.
And last question for me. Do you know the 7 years? I know there's like a complicated formula of how early in theory he could get out.
It's not that complicated. It doesn't take Einstein. Remember, E equals MC squared. Do we know that? Do I know? He has in his past that is affecting his ability to move forward and appropriately serve this sentence. Okay? His kids and his wife look forward to getting him back home.
That's right.
Thank you all so much for your time.
Well, you all were wonderful to me.
Nicole Westmoreland, WESTMORELAND.
And you're Nicole.
Yeah, that's okay.
High school.
I guess 3 shots.
Well, I would like to say for my YouTube community that we really think that you all were an amazing force to work with. You yourself, Attorney Westmoreland, is a first force to be reckoned with. When you speak, it's power. I talk about you being many and mighty. So, and I'm pretty sure for you that the family is very appreciative of all of the work that you both have done.
Well, we hope so. I mean, that's the ultimate goal is that's a person. And what is the right thing to do that society should do for this particular person, not for the general deterrence of others, but this is a human being. He has got a family. He comes clearly from a broken family. And we, as a society, want him to become that father that he didn't have, and his wife to be that mother that he didn't have. And we want him.
Appreciate you, Shannon P.
To be able to instill in his children the ability to move forward. That's the goal. That's the idea.
Well, you did a wonderful job of humanizing him. I appreciate it.
We appreciate it.
Thank you.
We appreciate it. It's a public trial, it's so important.
Yes.
It's essential for what we do, so we appreciate it.
Yeah, except for Jim.
Obviously.
To be tendered. And are we going to do them at the same time or separately? All right.
Turn her back
Are you ready,
around.
Ms. Bossy? All right. And he's handling this for the state.
You're right, it'll be Simone Hilton for the state.
All right. Thank you. All right, Ms. Ryan. Yeah, come up to the podium, and then Sergeant Ingram, can you swear Mr. Ryan on?
Yes, sir. Rodalius Ryan, R-O-D-A-L-I-U-S, Ryan, R-Y-A-N.
And Mr. Ryan, are you the same person referred to as Rodalius Ryan on indictment number 22SC-183?
Nah, you good, fam. You good, no one. I'm just saying, just future reference. Just be careful with it. But you good.
572?
Yes, ma'am.
Are you at this time under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you?
Currently 20 years old.
And how far did you go in school?
12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged in this indictment with count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organization Act, which carries a sentence of 5 to 20 years?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Nah, Shanna, I don't use StreamYard. I use OBS.
Have you had an opportunity to go over this plea of guilty and waiver of rights form with your attorney?
Yes, ma'am.
And have you and your attorney both reviewed it and you signed this document?
Yes, ma'am. That's my signature.
That's your signature?
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Leah Abbasi, about all of the facts and circumstances known to you regarding charges in this indictment?
Yes, ma'am.
Have you been able to speak with her about any potential defenses?
Yes, ma'am.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her counsel and representation?
We can curse, but you just gotta kind of put a whatever substitute letter or something like that, because you know YouTube will be blocking y'all comments. I just want y'all to be seen so YouTube don't be blocking y'all posts, but it's not like, you know, a language thing. It's just so they don't flag it. That's all. They have automatic bots that flag curse words. But no biggie, no biggie. Just letting y'all know. Ain't no issue. We rocking and rolling. We almost up out of here.
Yes, ma'am.
You also had another attorney, Ms. Angela D. Williams. Are you satisfied with her counsel and representation?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes, ma'am.
And do you waive any defects, if any, with respect to the indictment?
No, ma'am. Can you repeat that for me?
Sure. Do you waive any and all defects in the indictment?
Yes.
And have you been arrested on these charges, specifically count 1, the conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act?
He was already in custody, so he was not taken into custody for these charges. However, he was booked for the charges in the Fulton County Jail.
And he was served with the arrest warrants on this?
Yes.
Has Ms. Abbasi advised you of the minimum and maximum sentence for the charge that you are pleading to?
Yes, ma'am.
She said minimum and maximum. The minimum and maximum.
Has Ms. Abbasi advised you of the minimum and maximum sentence for the charge that you are pleading to?
Yes, ma'am.
Do you understand this is a negotiated plea of guilty which means that the state will recommend to the court a sentence of 10 years to serve commuted to the time you have served in this case. Do you understand that?
Yes, ma'am.
And do you understand that this sentence should run concurrently with the sentence that you are already serving for 19 SC 168236? Do you understand that?
Yes, ma'am.
Do you understand that the court does not have to accept this recommendation?
Yes, ma'am.
And the court can sentence you to the maximum on this charge?
I understand.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that you are not in the United States?
I thought it showed, Mookie. It didn't show. It showed on there. It showed earlier. Unless the thing was blocking it. But I think it showed. I laughed at it.
You understand the conviction sentence? That one? The one on enhancing sentence?
Yes, I just needed to explain a bit more what that means.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, and transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health offenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, evidence, and with a full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes, ma'am.
Do you also understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
And do you also understand that you have until the end of this term of court to file a motion seeking to withdraw your guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed and continue with trial, Your Honor, evidence has shown and will further show that Mr. Ryan conspired with others to participate in the Young Slime Life gang through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature and dominance of Young Slime Life, aka YSL. Your Honor, the court has been present for evidence regarding the February 23rd, 2019 homicide of Mr. Jamari Holmes, in which Mr. Ryan and YSL co-conspirator Damon Blaylock lured both Jamari Holmes, Bernard Mitchell, and Rodney Hooten to an apartment at 50 Mount Zion Road, which is in the Cleveland Avenue area. The evidence came out that during the course of that incident that Mr. Ryan, along with Mr. Blaylock, emerged from the apartment complex shooting at the vehicle which Mr. Holmes, Mr. Hooten, and Mr. Mitchell were in, shooting Mr. Holmes in the head. After this incident, a few hours later, Mr. Ryan is seen posting on social media, on a public social media post, saying that YSL makes the news. There has been other social media posts in which Mr. Ryan has promoted or enhanced the reputation of YSL. Your Honor, the state intended to show further evidence.
Miss D said, "Y'all all right tonight? What's going on?"
That once Mr. Ryan was convicted
Appreciate you,
of
fellas.
the homicide of Mr. Holmes while in prison, he continued to enhance the reputation, power, and territory of YSL. Specifically, when YSL co-conspirator and co-defendant Christian Eppinger was given a bond for shooting at an Atlanta police officer, Mr. Ryan, while on a contraband phone in prison, posted on his social media accounts He flashed the YSL sign and stated, "We're coming to get you." YSL shits, free my inward breath, F the DA, the gangway, we catching fines on this shit. Your Honor, this is the evidence that the state would have.
Yeah, I got you, Laugh. That's how you could spell the SHIT, $, exclamation point, stuff like that. Or whatever else you want to use to fill it in. That's just an example. Appreciate you, Laugh.
Intended to show if we would continue the trial. Given the current status, Your Honor, we made an offer to Mr. Ryan for this commuted to time served offers from my concurrent with his current conviction, Your Honor. And I can approach with the documentation.
You may. And I wanted to just add one thing to the information about the different methods you have to file things after this plea, and that is that Misty Williams and Ms. Abbasi will represent you until either the end of this term of court or 30 days, whichever's later, and so they would be the ones to talk to about filing those things, unless either of them is permitted to withdraw before that time. They would be the ones to file those for you, okay? Yeah. All right, Ms. Abbasi, is there anything that the defense wants to add to the record?
Yes, Your Honor. Your Honor, I have had the honor really of representing Mr. Ryan along with Misty Williams, so I'm quite disappointed she could not be here today for an important day. This trial has been exhausting for everybody, and that certainly includes Mr. Ryan, who has been going through the court system since he was 15 years old. We categorically and adamantly deny that YSL is the criminal, dangerous street gang which it's been made out to be through this trial. We're actually quite happy with the record which was established during the presentation of the state's evidence of the alleged murder of Mr. Jamari Holmes. This plea today, Mr. Ryan is making a decision which is going to be the best for his future, what future he has, because he's already serving a life sentence. Were he to be convicted and sentenced to additional time, he would remain in custody. As I stated, we think the record established will strongly support his appeal, and hopefully, when his conviction is overturned, we don't want him sitting in prison for something else. Certainly not for actions he took when he was younger, and actions he took which are largely a product of how he grew up. As I stated, Your Honor, Mr. Ryan was 15 years old at the time of the Jamari Holmes murder. You've seen through the text messages, he was out at all different hours, doing all different things, which I don't think anyone would want their 15-year-old to be out doing. And so that is where he was, and so he did adopt the people who were around him, the people who could support him, the people in his neighborhood who grouped themselves, calling themselves YSL. Mr. Ryan at no point was trying to advance a criminal street gang and their interests. He was trying to protect himself, being a young person, largely on his own, and this is where he's ended up. I would like to say that there's been some sort of rehabilitative function here since he was sentenced to prison. It doesn't appear that that has happened. As you've heard, some of his additional cases are within the prison system. It would be wonderful if some of the money...
Y'all go and show Laugh some love on TikTok and Instagram. Same name. Laugh Always Have Fun. Show her some love.
...spent on a case like this could possibly be invested in the future of people like Mr. Ryan, who go into custody at such a young age, and who really then are not given the resources to make the changes that they really would like to make to have a productive future. With all of that said, I think Mr. Ryan has grown up a lot during this trial. He doesn't want to sit through this anymore. He doesn't want to ever be back in a courtroom ever again, Your Honor. He's heard about all sorts of incidents, which the 2015 crimes, he was 11 years old. Mr. Ryan's most sincere wish is to move on with his life, to put this behind him. And we thank the court for the opportunity to resolve the case in this way and not drag it out any further than it has been. He just would like to thank the court, Judge.
All right, thank you. And Mr. Ryan, I just want to make sure that you understand that this is ultimately, the decision is yours to make, not your attorneys, and I appreciate that Ms. Abbasi and Misty Williams have been available in giving you legal advice and guidance, but it's ultimately your decision. Do you understand that?
Yes, ma'am.
All right, and do you in fact want to plead guilty?
Yes, ma'am.
All right, and you've had enough time to think about it and to discuss it with your attorneys?
Yes, ma'am.
All right. And Ms. Bossy, have you
Shout out to Kentucky.
and or Mr. Williams talked to Mr. Ryan about the benefits and drawbacks of all of his different options?
Yes.
Did anybody drop Charlie Hager link in here yet? Didn't somebody? I think somebody said that he has content, didn't he? Can somebody drop his link, please, if he make content? I want to check him out. Appreciate y'all, family. Hit the like, hit the subscribe, tap in, share with a friend.
Your Honor.
All right. All right. I find that there is a factual basis for the guilty plea to count one, the conspiracy to violate the RICO Act. Whatever the difference of opinion may be with regard to what YSL is or isn't, and what Mr. Ryan may or may not have intended. There is a factual basis that exists from the record, as it already is in this case, to support the necessary elements of the conspiracy to violate the RICO Act. And I have heard many of the alleged overt acts and the conspiracy evidence to advance the enterprise through a pattern of racketeering activity and to control personal property and money, and I find that the factual basis for that exists. And I am going to accept Mr. Ryan's guilty plea. I find it to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences of this plea. And I'm going to sentence in accord with the recommendation that both of the state and the defense have worked hard to negotiate here, which is a sentence of 10 years commuted to time served and to be run concurrently with the sentence that Mr. Ryan is currently serving. And certainly within the court's consideration is the knowledge that Mr. Ryan is at this time serving a life sentence for the murder of Mr. Holmes. And while I understand that that is on appeal right now, you know, those are the...
Oh, never mind. Scratch that. I just went to your channel, Charlie. I don't know why I thought on one of the past streams y'all was saying you had some content. Am I wrong or no? I didn't see nothing on your channel, though.
Facts as they exist right now. So that is the sentence of this court. Mr. Ryan, at 20 years old, you have most of your life ahead of you, and I don't know what it is going to hold with regard to your appeal or anything after that. But whether it is more years in custody or...
Be safe, Mookie Mookie. Appreciate you, family.
Or whether at some point in time you see the light of day to the outside world again, which is very likely considering your age, as long as you behave yourself while you're incarcerated and do not continue to either commit crimes in prison or violate any of the prison rules. If you can be on the straight and narrow, then somebody your age, after serving some amount of time, is probably going to be considered favorably for parole.
Yo, Joanna, I don't think he was 11 when they put the RICO on him. He was 11 back when all this stuff was started happening in 2015 when they started the investigation. He was just a kid. I think that's what they were saying.
And you just have to keep that in mind, that you need to be looking out for sort of the long run and not playing the short game, but playing the long game so that you have a future in front of you still. So that is your sentence, and I wish you luck, and I wish that with further maturity, much like Ms. Abbasi has said that you have already exhibited throughout the course of this trial, that you are able to make better decisions and steer your life in a better direction. Thank you.
Thank you.
Mr. Matthews, are y'all ready? All right. You may. Yes. And I'm going to go ahead and, where's Mr. Oster? Give you this documents. And then this one. All right, so we already have the signed copy of the indictment. Mr. Huey and Mr. Ryan have both signed, so I have that already. Yes.
No one dropped a new track. You can't stop me. Link in the chat. Y'all go check them out.
Okay.
Sub up. Hit the like button. Appreciate you, family. We wrapping it up. There's still some time, though. We still rocking. We still got some time.
All right, and Sergeant, if you can swear in Mr. Huey.
Marquavius Huey.
Governor, we have just received the redacted document here, so if I can have an opportunity just to execute the...
Absolutely.
Thank you.
Signing the, I guess it's still a, 5-page document. That
Doug had that jumpsuit on. I thought he was about to run up out the courtroom yesterday.
this is not the first time you're seeing the most of what's in that document, correct?
Absolutely
this is,
not.
Right.
We've
So
seen this.
there were a couple of items removed from the sentencing acknowledgments at your request. Is that right?
That is correct.
Okay. And otherwise, other than that section 4, everything has essentially stayed the same with regard to the rest of the document. Is that correct?
That is also correct.
All right. And you and Mr. Matthews.
Reggie Righteous link in the chat. Just dropped a new visualizer today.
And Mr. Huey were aware of the changes that were getting made.
Yes.
All right. Do y'all need any additional time to look over the refreshed document?
We do not.
All right.
I've reviewed it, and we are ready to
All
proceed.
right. Sounds good.
Okay, I have it.
No, that's all right. It's essentially the same.
Free Yak Gotti.
Okay, thank you.
Free Yak.
So you've got the waiver of rights and this separate kind of list of the charges and the sentences. Okay.
Free Shannon.
And the indictment is with Ms. Rosser. I'm ready whenever.
Will you please raise your right hand? Do you solemnly swear that the evidence shall give and the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Miss D 55 in Lil Woody voice at FFS. I think I'm speaking proper English.
I think he already got sworn, so you're double sworn at this point.
Please state your true and correct legal name.
Marquavius Huey. MARQUAVIUS. HUEY.
And are you the same Marquavius Huey on indictment 22 SC 183572?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you?
28.
And how far did you go in school?
12th grade high school diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you were in this indictment charged with count 1?
Okay, my fault, Charlie Hager. I thought somebody said that about you the other day.
One,
That you had
conspiracy to violate
content.
the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years.
Yes.
Count 3, you were initially charged with armed robbery, which carries a sentence of 10 to 20 years or life.
Yes.
You were charged with count 4 and 5 of this indictment, aggravated assault with a deadly weapon, which each carry a sentence of 1 to 20 years.
Yes.
You were charged with count 6 and count 7 in this indictment, which you charged with possession of a firearm or the commission of a felony.
Yes.
And that carries a sentence of 5 years to serve consecutive to any other count in the indictment.
Hey, I'm sure you can win too. You know, just go back and study my videos. You see everything you need to know of how to be a slimy DA.
Yes.
You were also charged with armed robbery in counts 14 and 15.
Yes.
Also charged with aggravated assault with a deadly weapon for counts 16 and 17.
Yes.
You were charged with hijacking a motor vehicle in the first degree.
Yes.
You were initially charged with possession of a firearm under the commission of a felony.
Yes.
Counts 19 and 20. You were charged with 4 counts of participation in criminal street gang activity, which were counts 21, 22, 23, and 46.
Yes.
And you were charged with possession of a weapon by an incarcerated individual, which was count 44, and possession of a telecommunication device by an incarcerated individual, which was count 45. You understand that those were your initial charges in this indictment?
Yes.
Do you
Post your content.
understand that you have the right to plead if you're guilty or not guilty of these charges?
Yes.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over this waiver of rights form with your attorneys?
Yes, ma'am.
And is this your signature on this document on page 4 of this document?
Yes.
Have you had enough time to speak with your attorneys, Carrington Matthews Sr. and Carrington Matthews Jr., about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this matter with your attorney?
No.
Are you satisfied with their counsel and representation?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes.
Do you waive any defects, if any, with respect to the indictment?
Yes.
Is it your understanding, have you been arrested on all of the charges contained within this indictment?
Yes.
And Mr. Matthews Jr., are you aware of any other outstanding warrants for these charges?
We are not aware of any.
Have your attorneys advised you of the minimum and maximum sentence for each charge that you are pleading to?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence?
Yes.
Let me tell you the sentence right now. As to count 1, which is conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, the state's recommendation is 20 years to serve 9 years in custody, the balance of 11 years on probation. As to count 3, armed robbery, based on the negotiations, the state will reduce the armed robbery to robbery and offer a sentence of 20 years to serve 9 years in custody, concurrent with count 1, the balance of 11 years on probation. As to count 4, aggravated assault with a deadly weapon, the state will recommend 20 years to serve 9 years in custody, concurrent with counts 1 and count 3, balance of 11 years on probation. As to count 5, aggravated assault with a deadly weapon, the state agrees to null pros or dismiss that count. As to count 6, possession of a firearm during the commission of a felony, the state's recommendation.
Slime Life Shorty came in and shut the whole case down. He was too honest for the whole case. Shut the whole case down.
Recommendation is 5 years to serve, consecutive to counts 1, 3, 4, 14, 15, and 44 to be suspended. As to count 7, possession of firearms during the commission of a felony, the state will null pros or dismiss that count. As to count 14, which is armed robbery, will reduce that to robbery, 20 years to serve 9 years in custody, concurrent with counts 1, 3, and 4, balance of 11 years on probation. Count 15.
If you were locked in the basement twice and just so happened to run across, just happened to magically find a cell phone that's working, and you know the code to open it, who you calling? You for sure calling the police first, 911, unless you unless you know Superman number or something.
Armed robbery reduced to robbery, 20 years to serve 9 years in custody, concurrent with counts 1, 3, 4, and 14, balance of 11 years on probation. Count 16 will be null pros or dismissed. Count 17, that count will merge with count 15. Count 18 will be null pros or dismissed by the state. Count 19, possession of a firearm during the commission of a felony, will be 5 years to serve, 5 years to serve consecutive to counts 1, 3, 4, 14, 15, 17, and 44, but concurrent with count 6, and that will be suspended. Count 20 will be null pros or dismissed by the state. Count 21 will be 5 years to serve, concurrent with counts 1, 3, 4, 14, 15, 16, 17, 19, and 44. Count 22 will be null pros or dismissed by the state, as well as count 23 will be null pros or dismissed by the state. Count 44, possession of a weapon by incarcerated individual.
Appreciate you, Miss Mama. Appreciate that.
Will be 5 years to serve, concurrent with counts 1, 3, 4, 14, 15, and 17. And counts 45 and 46 will be null pros or dismissed by the state. Do you understand that that's the state's recommendation?
Yes.
Do you understand that the total sentence is 25 years to serve 9 years in custody with a balance of 14 years? 9 of those 14 years will be served on probation, and 5 years will be suspended. Do you understand that?
Yes.
Do you understand that the court does not accept that recommendation?
Yes.
And the court can sentence you to the maximum of each charge and can run those charges consecutively, one after the other.
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand that you are currently on probation or parole? Your probation or parole may be revoked based on your entering a guilty plea today.
Yes.
Do you understand if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions without being subject to revocation for the balance of the sentence?
Yes.
And do you understand that there were several special conditions of probation that you must adhere to, which are contained within this documentation?
Yes.
And have you had an opportunity to go over each of these special conditions with your attorney?
You only get one call when you locked in the basement? Like a prison? You get one call. It's a phone over there, but it's only one dial. No, I think she was asking, who would you call first? Would you call your mama first, your auntie first, or the 911 to tell them that you locked in the basement?
Yes, ma'am.
And did you also go over with your attorneys your sentencing acknowledgments regarding this plea agreement?
Yes.
And is this also your signature on this documentation with your attorney going over each of the sentencing, each of the special conditions of probation?
Yes.
And did you fully understand the special conditions of probation?
Yes, ma'am.
Ms. Hilton, can you pass that document up to the court, please?
She about to say, pass that Dutch. Miss Hilton, can you pass that Dutch? It's time to smoke.
Did you want to review before I continue?
No, that's fine. Go ahead.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Hey, what up, Billy Gates? Grand Rising. You up in the UK just waking up, huh? I see you, family. Appreciate you joining.
Yes.
Do you understand that you are not a United States citizen? A guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of being advised by your attorney or anyone else?
Yes.
Do you understand that neither the courts, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will
Math ain't mathing.
be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering
Lady Justice is blind. Everybody can get it.
You have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself.
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights, and after each right, I'll ask you to respond. The right to trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assistant counsel hired by you,
Lady Justice is blind. Everybody can get it.
Yes.
the right to presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
With respect to indictment 22 SC 183572, how do you plead to the charges in that indictment?
I plead guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
And do you understand that you have until the end of this term of court to file a motion seeking to withdraw your guilty plea?
Yes.
Your Honor, if this case were to go to trial, the state will expect.
Michelle Corley, what up, fam? Appreciate you for joining. Thug is out. Hey.
If we were to continue this trial, the state would expect to show, or Evidence has shown and will show that Mr. Huey conspired with others to participate in YSL through a pattern of racketeering activity, and multiple defendants, as well as unindicted co-conspirators, have committed overt acts to further this conspiracy, to include drug sales, aggravated assault, and murder. Also, it includes posting on social media, asserting the violent nature of and the dominance of Young Slime Life, aka YSL. Specifically, Mr. Huey himself participated in 2 robberies. He posted on social media, and he engaged in text messages with his fellow co-conspirators. On April 26, 2019, Mr. Huey, along with another individual, armed robber Mr. Nawab Maynard, at an apartment complex located on Masargo Drive in the Buckhead neighborhood in Atlanta, Georgia, Fulton County. He robbed Mr. Maynard at gunpoint and pistol with him. Mr. Huey was wearing a very distinct...
No offense to anyone. I just wanted to make sure we got that on record.
...yellow jacket. He stole a ring, a necklace, a luxury wallet, and other items. He then fled the scene in a black Mustang. Portion of this robbery, Your Honor, were caught on surveillance video. After the robbery, Mr. Huey was seen on his social media account with the ring and necklace that were identical to the items that were stolen from Mr. Maynard. Additionally, on IG, on Instagram, on social media, there were several pictures of Mr. Huey photographed next to a black Mustang. There were several pictures. Lastly, there were pictures of Mr. Huey on his social media wearing the same distinctive yellow jacket that was seen on the surveillance video. Based on that evidence, Your Honor, arrest warrants were...
Shout out to Michelle Corley. Y'all gonna drop some slime brellas in the chat for Michelle. Appreciate you, family. Drop some MCs and some slime brellas and some slime emojis.
Issued for Mr. Huey. While on bond for the April 2019 armed robbery, Your Honor, on October 1st, 2020, Mr. Huey went to the apartments located at 250 Bolton Street, Atlanta, Georgia, Fulton County, to meet with Mr. Gary Holloman. Gary Holloman, who is now deceased, told law enforcement officers on the night that he was robbed that Mr. Huey, who he knew, asked to meet with him so that Mr. Holloman could give Mr. Huey money to put on another co-conspirator, Tinquarius Mender's books or commissary at the Fulton County Jail. Tinquarius Mender, who is a co-defendant and co-conspirator, is the nephew of Gary Holloman. Mr. Mender and Mr. Huey were friends or are friends. Mr. Holloman agreed to meet with Mr. Huey at the location. While at the location, Mr. Huey, along with another individual, approached Mr. Holloman. One person had an assault rifle. They took from Mr. Holloman his car and his money. They also robbed another young lady by the name of Misha Coppage. Mr. Huey and the other unidentified individual fled the scene and left. Mr. Holloman immediately called the police. When police arrived, Mr. Holloman was able to use another cell phone to track his phone. He was able to track that phone going in the direction of I-75 South, and ultimately that phone was located on Oak Drive, which is in the Cleveland Avenue area, which is the area or territory for Young Slime Life. Also, Mr. Holloman was able to show police officers the social media pages of Mr. Huey to identify him. Initially, the police marked this case as an information, and the case was not initially investigated. However, about 1 month later, Mr. Holloman went to the police headquarters, spoke with investigators. He was able to pick Mr. Huey out of the photographic lineup. Subsequently, investigator Marissa Viverito, who was formerly with the Fulton County District Attorney's Office, found a jail call with Tinquarius Mender, Mr. Mender's mother, as well as Gary Holloman discussing the robbery, and Mr. Holloman discussing what occurred to him. Arrest warrants were taken out for Mr. Huey. He was initially arrested in November of 2020. During that arrest, and pursuant to a search warrant, his home was searched. In that search, they found 2 rifles, 2 rifle handguns. Also, they found items belonging to an individual by the name of Chandler Durham. During that search warrant, they seized Mr. Huey's phones, and pursuant to a search warrant, did a search of those phones. Upon seeing the items from Chandler Durham, investigator Viverito checked the Atlanta Police Department's database to find out there were any police reports associated with the Chandler Durham. She found a police report from March 12, 2020. In that report, Chandler Durham reported that while he was working at a music studio, his car and additional items to include a luxury bag were stolen. After finding the report, investigator Viverito went through the contents of Mr. Huey's phone, and she saw a few text messages and notes. She saw a text conversation on March 12, 2020 between Jeffrey Williams and Mr. Huey. Jeffrey Williams told Mr. Huey that they needed to take that shit back. Mr. Huey denied involvement in taking the items and blamed it on another person. Mr. Williams then told Mr. Huey in this text message, if he doesn't take it back, he's going to die. Also found in Huey's cell phone were 2 incidents in which Mr. Huey and Mr. Williams were in conversation with each other regarding rival gang member Rashawn Bennett, aka YSL. On January 19, 2020, Mr. Williams sent a flyer to Huey with the performance location of Milton Lloyd Retail, along with to resolve this case with insurance.
Okay,
Yes,
and in your global sentence, it says 5 years suspended, and so I assume that that's what y'all meant by that.
Yes.
So, with regard to the offer, I just wanted to be clear that on counts 6 and 19, which are possession of a firearm during the commission of a crime, while this 5-page plea agreement document reflects that those are going to be served on probation, the intention of both parties is that those 2 counts be suspended. Is that right?
Yes, sure.
Okay,
Yes, sure.
and in your global sentence, it says 5 years suspended, and so I assume that that's what y'all meant by that.
Yes, Your Honor.
Okay. All right. Mr. Matthews?
Yes, Your Honor. Good afternoon to this honorable court, Your Honor. I'd like to begin by expressing to the court that we emphatically and categorically deny all of the recitation that's been presented by the court with respect to some of these allegations that's been laid out by the state. However, we do recognize that there are enough factual allegations in the recitation to support each and every count to which Mr. Huey is pleading this afternoon. So we do stipulate that there is enough to move forward with this plea. For those reasons, Your Honor, we are standing before this court to talk to this court about the acceptance of responsibility with respect to Mr. Marquavius Huey. Your Honor, Mr. Marquavius Huey was born in Atlanta, Georgia. He lived in the Jonesboro South community, a neighborhood project in the Atlanta community. He grew up there. He's seen a lot of things in his short 28-year life. His father was murdered in 2010, and he's been without a father for a number of years. He's been raised by his mother as a single parent. He has a number of siblings. There have been times when Mr. Huey and his mother and his family.
Appreciate you, Shanna. She say, y'all gonna make me have to get a refill. Love this channel. Flesh of the God, you have a great community here. Appreciate you, family. Y'all do help me make the community great. I'm slurring my words because I didn't have a shot myself. Y'all help me make the community great. Appreciate y'all, family. Let's keep it going. We almost up out of here.
Have been homeless and have lived out of a car. So he's had a very, very hard life as it relates to his upbringing. Notwithstanding that, Your Honor, he did manage to graduate from high school. Mr. Huey, Your Honor, now has 2 children. He's 28 years old. He has 2 children. He has a 5-year-old son, Your Honor. He has a 2-year-old little daughter that was born in July of 2022. He has never met or seen his daughter in person until today, as she's here in this courtroom. He recognizes that choices puts him before this court in this case. Your Honor, we are asking this court to take into consideration that he has no prior felony convictions. I've had a very long time to get to know Mr. Huey because I've been with Mr. Huey on a regular, daily basis during the week since January of 2023. I've got a chance to know him. I've got a chance to work with him on his case regularly. And he wants to, when he gets out of custody, Your Honor, he wants to do a number of things, 2 in particular. He wants to start and become affiliated with a nonprofit organization where he can be able to talk to young children, teenagers.
Hey, Jerome, that's low-key a fact, though, because she could have been an ass and just said 20 years. I'm giving them the max of the 5 to 20. I'm going to give you the whole 20. Or the whole 45, the 40 that it added up to. That would have been fucked up. Or half of that, even half of that, yeah, 20, that would have been shady.
Because he was a teenager when he lost his father. And things begin to take a turn for Mr. Huey. He wants to be able to tell teenagers, young boys, young black boys, he wants to be able to say to them, don't do what I did. And you have another way in which you can go. And he wants to be able to share his experiences in that way. I have linked Mr. Huey up with an organization called Young Generation Movement, and I've known that nonprofit organization and the founder of that organization for a long period of time. He's also present in this courtroom, and I've linked Mr. Huey up with them so that when Mr. Huey gets out of custody, he will be able to have an organization that can mentor him, that he can align himself with, where he can begin to engage himself with anti-violence nonprofit conduct and mentoring other young people. He also, in terms of being able to earn an income, because he is now, Your Honor, if this court accepts this plea, Mr. Huey will now, for the first time, be a convicted felon. He is not first offender eligible. He wants to get his commercial driver's license, Your Honor, and he wants to get a trucking company and be able to earn a living for himself, because he recognizes that it's going to be a challenge for him to be able to go out and apply for jobs and be able to get income by getting an employer to hire him. So he's going to focus and target himself to be able to fend for himself so that he can take care of his young children that he has helped to bring into this world. Your Honor, we are here before.
Have a great one, Lav. Keep it rolling while you pass out. Appreciate you, family.
For this court, because it's an acceptance of responsibility. We recognize that this has been a very long, enduring trial, and we have come to a point where we have painstakingly negotiated with the state of Georgia, and we've come up with a negotiated resolution that we believe is one that is fair. We believe that is sufficient to recognize the seriousness of the charges that are before the court, and we believe it's one that will cause Mr. Huey to be able to see the light of day in a reasonable period of time. Mr. Huey has been in custody. I'd like to enter into the record, Your Honor, as Defendant's Exhibit 1 for sentencing purposes, a proof of incarceration from the Fulton County Sheriff's Office. Mr. Huey, through the computations of the various times when he was arrested on these charges and released, and from the time that he's currently been in custody to the present, he has approximately 4 years under his belt against that 9-year sentence, and that 9-year sentence is parolable. So we're going to enter that as an exhibit before the court.
All right, that'll be Defendant's Exhibit 1 to this plea hearing, and as you know, and as I'm sure you have shared with Mr. Huey, it's ultimately the Department of Corrections that calculates the time served portion of the sentence, so it'll ultimately be up to them, but I will include that as a part of my sentencing sheet as well.
Thank you, Your Honor. Thank you. It's been an absolute pleasure and honor to represent Mr. Marquavius Huey along with my son, Attorney Carlton Matthews Jr., who also would like to address the court at this time, Your Honor. So we're asking this court to accept the negotiation that has been represented to the court, and Mr. C.J. Matthews.
Yes, good afternoon to this honorable court.
Good afternoon, Mr. Matthews.
I've been gracious with this opportunity to represent and serve Mr. Huey. Mr. Huey is an honorable young man. Mr. Huey does not allow his mistakes to define him, but he is remorseful, Your Honor. He has learned, grown, and became a better man during this trial. Mr. Huey will have a release date, Your Honor. I'm confident in him that he'll be a
What up, Slimy? I see you, family. Appreciate you joining.
working class citizen in society when he is released. We thank this honorable court and respectfully ask this court to accept this plea on today.
All right, thank you, Mr. Matthews.
Slimy in the house.
Mr. Huey, I am sure that Mr. Matthews Sr. and Mr. Matthews Jr. have, I know that they have been working with you and negotiating with the state for over, I'm sure, the entire course of this trial and proceeding, but very, very hard over the last week and a couple of days to get where we are right now. And I know that you know that given the severity and the number of charges that you were facing, that had you been convicted of all of those charges at trial, you were looking at the possibility of 3 consecutive life sentences, plus I think about 100 years after that. So the fact that the state is recommending jointly with your attorneys that your total sentence be 25 years with 9 of those to serve is, it's frankly remarkable, and something that you should not take for granted or take lightly at all. These are very serious charges. And I hear what both Mr. Matthews have said about the challenges facing you in your life, and I am sorry for the loss of your father. One would hope that to have anybody that they love taken from them in a violent way like murder might have an impact upon their lives that would lead them in the right direction, but it's not particularly surprising that sometimes that's not what happens and it goes in a worse direction instead. I hope that with your age and with having really been faced with the distinct possibility of spending the entirety of the rest of your life in prison, the fact that you are getting this opportunity is not going to be wasted. I hope that you appreciate what the Matthews have done to go out of their way to line up somebody to be looking out for you when you are released from prison. And I want to ask you, just like I have asked both Mr. Nichols and Mr. Ryan, is this your decision to enter this guilty plea? Because no matter what your attorney's advice is, it's ultimately up to you whether to plead guilty or continue with the trial. So is this what you want to do?
Yes, ma'am.
All right. And have you had enough time to consider all of the different scenarios and to discuss everything you wanted to with your attorneys?
Yes, ma'am.
All right. All right. I think it's very clear that this plea is to your benefit, considering the potential downside of moving forward with the continued trial. I find there to be a factual basis to this plea. I appreciate the fact that y'all have stipulated that there is a factual basis. And I find the plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I will accept it as such. And I will sentence in accord with the negotiated recommendation. I'm not going to read everything out again. We thankfully got it in writing for the sentence sheet, but in accord with what was put on the record and what is reflected in this this document, with a total sentence of 25 years to serve 9 in custody, balance of 14 years after that, 9 of those on probation and 5 suspended. And I'm going to impose the special conditions that you have already acknowledged and acknowledged that you would abide by. And, you know, somebody with a high school diploma, which is more than a whole lot of people ever achieve. So you've already achieved and proven that you can achieve good things. And who is only 28 years old, and who can really look down and already see the light of day for a release date. You need to make sure that during your time incarcerated that you don't pull any of the kind of thing that you have been, you know, that you actually are pleading guilty to, at least some of, by having contraband or in any other way getting in trouble, because that's not going to bode well. I am going to recommend a transition program for you. I know that there's a lot of different job training available in our correction system, so I hope that you take advantage of that. And you know, whether it's a commercial driver's license or whether you find something else that you want to do while you're in there.
Joanna said the mama locked her back in the basement after she came home.
Be making good use of your time while you're in there and furthering yourself. And you have had a fine example next to you for the past 2 years of what somebody can do with their lives. So don't forget about that, and be the father that you need to be and that you ought to be to your very young children. They're still going to be very young when you get out. And please make sure that you abide by all your probationary conditions, because if you don't, then you're going to be back to see me. And because I recognize how much of a break you're getting right now, I'm probably not going to be as lenient if you come back before me again, because you are getting a huge opportunity to turn your life around, okay?
Yes, ma'am.
All right, so that's the sentence of the court, and I want to wish you good luck and good fortune. You can get through the next few years, and then you can have the rest of your life to do good work with.
Can you address the court?
Yes. I should have asked that. I'm sorry.
That's okay, Judge. Thank you.
I want to thank the court and thank God. And I want to apologize to my kids, my family, and everybody who supported me in this stressful process. I plan to do my time, come back, be a better man.
I'm glad to hear that. Thank you.
Your Honor. Thank you.
All right.
All right, family. One more to go, and we wrapping it up for the night.
All right, let's take a recess.
Hit the like, hit the subscribe, tap in, share with a friend. Appreciate the love. We wrapping it up. Appreciate y'all riding it out, toughing it out with me. I know we on a late night shift, but we here celebrating. Thug free. We knew it was gonna happen. This ain't how we expected it, but we knew it was gonna happen. We knew they was full of shit, and it's been proven over and over again and over again for 150 something days.
Mr. Harvey, Ms. Westmoreland, and Mr. Garland, who's going to be
technically for what 900 plus days? Actually, over 900 days since Thug got locked up.
taking the lead going through the plea? Okay. All right, Mr. Harvey, do either you or you, Ms. Hilton, need this plea of guilty and waiver of rights form back?
Yo, Michelle Corley, the points are free chat points. They add up as you chat. Well, not each chat. They go by a time frame. So every so many minutes they add up. You could use exclamation point free thug, all one word, to check your chat balance. You can use it to alter the stream. You can use the points to alter the stream. You see at the bottom they have the code scrolling like exclamation point gatekeeper. An exclamation point, Lovezilla, power up stream, different stuff like that. You can alter the stream. So when you see that stuff popping up, a lot of times that's the chat members using their points. Appreciate you, family.
All right, Mr. Nichols and Mr. Harvey, whenever y'all are ready, you can come on up to the podium.
Like that right there. That was Steph JK. Steph JK just activated that. Appreciate you, family.
Mr. Harvey said he's signing the indictment.
Okay. Whenever y'all are ready.
Your Honor, I'd like my client to be present for this. He's a member of the public, and I would like him to observe this. And he has a right to be here.
Okay.
Thank you.
Can we get
Great,
Mr. Kendrick out, please?
Gatekeeper.
And we'll let y'all back.
Okay, my name is Quamarvius Nichols. First name Quamarvious. My last name Nichols, Nichols.
And Mr. Nichols, are you the same person referred to as Quamarvius Nichols on
Look, he said Quamarvius. She said Quamarvius. Is it Qua or Quay?
indictment 22 SC 183572?
Yes.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Have you had the opportunity to sign this indictment with your attorney, Mr. Harvey?
What? FFS using chat points? What? I thought you was stacking up. That's what I'm talking about. Appreciate you, family.
Yes.
How old are you?
29.
And how far did you go in school?
I got my GED.
Yo, Joanna, check in my description of the videos and get my email and send me an email so we could set up a panel. We could do a panel show together. We scheduled it up. Appreciate you, family.
I hear you.
I got my GED.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that in this indictment, you were initially charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carried a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that's what you were initially charged with?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Oh yeah, you do always be hitting the hair, boy, and that's crazy because I don't have the points actually connected. So you been getting those for free. I ain't even been charging for those. I got to get my points connected.
Have you had an opportunity to go over and review the waiver of rights form with your attorney?
Yes.
And I'm going to hand this to your attorney. Did you sign this along with your attorney?
Yes.
Have you had enough time to speak with Ms. Harvey about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Do you need any more time to discuss this matter with your attorney?
No.
Are you satisfied with his counsel and representation?
Yes.
And I'd include in there the counsel and representation by Ms. Westmoreland and Mr. Garland as well. You had a team of attorneys.
That's correct.
All right.
And they are all attorneys of record and have participated in this particular proceeding and negotiations leading up to this proceeding.
Thank you.
Do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects with respect to the indictment?
Yes.
And to your knowledge, have you been arrested on all the charges in this indictment?
Yes.
And Mr. Harvey, the state is unaware of any outstanding warrants related to these charges. Do you know of any outstanding warrants that are related to these charges?
Not related to those charges.
Have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balanced on probation?
Yes.
Do you understand as a part of the negotiated agreement, the state will null, process, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon. Do you understand that is a negotiated agreement?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
Yes.
Well, there's only one charge that
so
a guilty plea is being entered into, so there's no other sentence to run anything consecutively with regard to this plea. You understand that?
Yes.
Okay.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being
The here boy pulled up Jack. He over here dancing for subs. Y'all got to sub up. Show Jack some love.
subject to revocation for the balance of your sentence?
Yes.
Do you understand you are not allowed to possess
If you don't sub, he don't eat. He don't eat if you don't sub. Y'all got to subscribe. Appreciate you, family.
or use a firearm while on probation?
Yes.
Do you understand if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of getting advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Lady Justice is blind. Everybody can get
Office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony,
Christine Covey with the snow out there, huh? Be safe, family. You must be on the east or up north somewhere.
if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against?
Hey, I did say Shauna a couple times, but then when I was thinking about it, I was like, oh, I think it's Shanna. But okay, Shauna, thank you. That's easier, actually. Appreciate you, family. Shout out to Shauna.
Against you, and the right to testify to remain silent and not incriminate yourself.
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? After each right, I'll ask you to say yes or no if you understand. The right to a trial by jury.
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses against you.
Yes.
The right to assist with counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proved beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights?
Leave one call phones. It only got 1 minute. Like, you remember the ones you used to put minutes on the phone? You only leave 1 minute on there. So they can only make one call just in case they get locked in the basement and want to call their mama or their grandma or their auntie.
Enter a guilty plea because you're in fact guilty.
Yes.
No, I mean, just in case you lock them in the basement and they need to call their mama or their grandma or their auntie.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the racketeer?
Also,
respect additional March of also see Nichols Relator, check with there they chased through the city of East Point and
Committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy. A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
well, that's what the language of the statute says, but
Yes.
he is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations other than those two events that are sufficient for a factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are, substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act. But yes, we acknowledge a factual basis to that extent, Your Honor.
Understood. All right, thank you.
Your Honor, we just have one additional thing to say.
Go ahead.
The factual basis regarding the Nation YSL.
Thing that is necessary to meet the factual evidence of a 1614. Once again, we
Also including social media posts asserting the violent nature of and asserted dominance of Young Limelight, also known as YSL. And that concludes our factual basis.
And again, once again, we again categorically deny those representations. And again, the only thing that is necessary to meet the factual evidence of a 1614(4)(c) is proof that the defendant conspire with another person to violate one of the substantive provisions of RICO, and that is subsumed by the drug offenses that have already been proven in this case, and to which Mr. Nichols has previously pled.
All right, thank you. Understood.
And Your Honor, I approach with the waiver rights form.
Yes. All right, Mr. Harvey, have you reviewed with Mr. Nichols this plea of guilty and waiver of rights form, which the two of you have both signed?
I have, Judge, in each individual provision in that plea colloquy has been acknowledged and gone over personally with Mr. Nichols.
YP said I fell asleep. I feel you, family. We almost up out of here. I'm getting tired myself. 10 more minutes and we out of here. Appreciate you, family. Shit, 8 more minutes.
All right. And Mr. Nichols, have you had sufficient time to consider this guilty plea that has been negotiated between the state and your attorneys, and to discuss anything you wanted to about that with your attorneys?
Yes.
All right. And you understand, I hope, I'm going to ask you, that it is your decision ultimately, obviously with the advice.
Over the pond, over the seas. Over the pond. Shout out to UK.
Of your attorneys, but it's ultimately up to you individually to decide whether you want to enter this guilty plea or not. Do you understand that?
Yes.
All right. And you do want to enter this
You said you in Alaska? What? I know it's cold out there.
guilty plea?
Yes.
All right. And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does not ultimately go through with his guilty plea and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
very thoroughly, Judge.
All right. All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than the state.
I'm trying to stick with my first mind. I usually be pretty good with the name pronunciation. I just can't read.
With regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days and he will be 30. And at 30 years of age, he has a wife. He has got a 13-year-old daughter. He's got a 10-year-old daughter and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta. And, you know, we're at this point, before I have even given my opening statement in this case.
Yes, sir.
I do want the court to know that Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area. So he has come to this point in his life from a very humble beginning. And he has sought the support of friends in this courtroom and others in this courtroom. He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence.
Next show on Saturday, family.
You
can come feed them on Saturday. Next show on Saturday. Appreciate you, family. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend.
In his best interest, I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I ask the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. All right. I find there to be a factual basis for the guilty plea to the RICO count one of the indictment, that being a conspiracy to acquire control or interest in money and personal property through a pattern of racketeering activity. And
happy November, Miss D. Appreciate you, family.
that is the only count that guilty plea is being entered for. The remaining counts of this indictment as against Mr. Nichols are being null pros by the state as a part of this indictment. I find, having heard the evidence up to the point of trial right now, that there is evidence of at least one overt act in furtherance of the conspiracy, and that there is evidence that would fall within the required statute of limitations to establish this RICO conspiracy count. One of the things that we as judges are instructed by our Uniform Superior Court rules to do when we are considering whether to accept a guilty plea and whether to accept a negotiated sentence, and this is a negotiated sentence in this case, is to take into account whether giving leniency in sentencing is going to aid in ensuring promptness and certainty, or at least more promptness and more certainty with regard to corrective measures, whether the defendant, and in this case, the defendant has acknowledged guilt and is accepting responsibility for his guilt of the RICO count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count 1 of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count 1 is the sentence that has been negotiated of 20 years to serve 7, with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special conditions in those, so there are none as far as I'm concerned.
All right. Okay. So with regard to the time that you are on probation, you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you, and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe, Mr. Harvey is correct, can be a productive member of society, and this is an opportunity for you to do that and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you and set a good example for them, an example that I guess unfortunately you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you, Judge.
And Ms. Taylor will make this an exhibit to the plea. Thank you. All right, we are adjourned for the day.
We are adjourned for the day, family. Appreciate y'all being here. Hit the like, hit the subscribe, tap in.
You don't have to catch a body if you don't have to. Can't find solace with your past passing you.
No. Why didn't you, as an officer of this court, tell me? And that's not what the point is. The point is, you as an advocate, is you should have told me. I got a problem with you now. I got a problem with you now. I would suggest you don't say any more. Now you want to have it both ways. You can't do it. Both sides have an equal responsibility under the rules of professional responsibility. All right, have a seat, sir. Thank you.
How fast things have changed. How fast things have changed. How fast things have changed. Now I see you running, coming for my come up. Broke out all your shackles, turned it to some armor. Used to be the judge, but now you have no honor. To die with your pride is to live with all your karma. Now you understand. Now you understand.
Another night of crime. There's a lot of money talking about.
All right. Anybody else have any other issues as to...
Uh-oh. Fulton County has no problem coming in here and cuffing all of us, okay? Don't be an idiot.
Are you trying to tell me about myself? You homeless, and you don't even have a mirror to look at yourself.
FFS said, what's that post supposed to be? I'm over here falling asleep. It said, do you like and share? Share. Appreciate y'all, family. Appreciate the love.
Here. So I know you all about your principles. But can we just please just listen to Earl so we can get out of here? It's 4 cops on the other side of that door. You know if they come in here, they're gonna get your ass on a whole lot of other shit.
You lying ass bitch.
I knew it. Mama, I hate you, Will.
Don't you never come back to my house,
And
no.
I hope they blow your motherfucking ass to smithereens.
You better hope they do, bitch. You better hope they do.
This nigga kidnapped me.
I think I'm entitled. You want answers? I want the truth! You can't handle the truth! What are you, fucking nuts?
You thought...
All right. Appreciate you, family. Appreciate the great time y'all spent with me. I can't even think right now. I've been up since 4 this morning working on the stuff, but shout out to everybody still in the chat. Shauna, appreciate you, family. Shauna P. Law Nerd. Cha Diggy, appreciate you coming back. What up, though? Laugh always, have fun. What up, family? Appreciate you spending the night with us all night, not passing out on us. Appreciate the love. Chloe Albert's Revenge. What up? Appreciate you, family. Shay. Yeah, I did put Shay. Chadiggy, Steph JK holding it down. Appreciate you. Y'all show some love to the mods. Get them some love. Drop them blue hearts and ice creams and FFSs and all that mod love. Shout out to No One. Drop the gloves for No One. That's right. Drop the gloves. Shout out to Joanna. Welcome to the team. Drop some tool wrenches. Drop some wrenches. Joanna got a wrench now. Now we need to get you an emoji. Appreciate you, family. Charlie Hager. Appreciate you, family. Who else up in here? Appreciate y'all. YP Com Chick. Jerome Street. Drop some glasses in the chat for Jerome Street. Some beer mugs. Some cheers. Appreciate y'all. Okay, I'm seeing doubles now. Seeing doubles, my bad if I left y'all out. You know it's all love. Type something in the chat and I'll say your name before we roll out. Appreciate you, family.
No. Why didn't you, as an officer of this court, tell me? And that's not what the point is. The point is, you as an advocate, is you should have told me. I got a problem with you now. I got a problem with you now. I would suggest you don't say any more. Now you want to have it both ways. You can't do it. Both sides have an equal responsibility under the rules of professional responsibility. All right, have a seat, sir. Thank you.
How fast things have changed. How fast things have changed. How fast things have changed.
Now I see you running, coming for my come up. Broke out all your shackles, turned it to some armor. Used to be the judge, but now you have no honor. To die with your pride is to live with all your karma. Now you understand.
Also, I dropped the PayPal link in the chat. I be forgetting to put it in my chat, but y'all can donate via PayPal also. Appreciate you, family.
Now you understand.
Another night of fun. Then right up when they close it on.
All right. Anybody else have any other issues as to...
Uh-oh. Fulton County has no problem coming in here and cuffing all of us, okay? Don't be an idiot.
Are you trying to tell me about myself? You homeless, and you don't even have a mirror to look at yourself.
Here. So I know you all about your principles. But can we just please just listen to Earl so we can get out of here? It's 4 cops on the other side of that door. You know if they come in here, they're gonna get your ass on a whole lot of other shit.
You lying ass bitch.
I knew it. Mama, I hate you, Will.
Don't you never come back to my house,
And
no.
I hope they blow your motherfucking ass to smithereens.
You better hope they do, bitch. You better hope they do.
This nigga kidnapped me.
I think I'm entitled. You want answers? I want the truth! You can't handle the truth! What are you, fucking nuts? You thought? Oh.
Chloe Albert's revenge. Say my name, say my name. Gang, gang.
No. Why didn't you, as an officer of this court, tell me? And that's not what the point is. The point is, you as an advocate, is you should have told me. I got a problem with you now. I got a problem with you now. I would suggest you don't say any more. Now you want to have it both ways. You can't. Both sides have an equal responsibility under the rules. Professional responsibility. All right, have a seat, sir. Thank you.
Oh shit, PayPal link not working. Never mind, I gotta get it fixed. Appreciate y'all though, family.
How fast things have changed. How fast things have changed.
Now I see you running, coming for my come up. Broke out all your
Y'all go tap into Reggie Righteous new track. Appreciate y'all.
shackles, turned it to some armor. Used to be the judge, but now you have no honor. To die with your pride is to live with all your karma. Now you understand. Now you understand.
Another night of fun. There's a lot of fun to talk about.
All right. Anybody else have any other issues as to...
Uh-oh. Fulton County has no problem coming in here and cuffing all of us, okay? Don't be an idiot.
Are you trying to tell me about myself? You homeless, Ern. You don't even have a mirror to look at yourself.
Here. So I know you all about your principles. But can we just please just listen to Ern so we can get out of here? It's 4 cops on the other side of that door. You know if they come in here, they're gonna get your ass on a whole lot of other shit.
You lying ass bitch.
I knew it. Mama, I hate you, Will.
Don't you never come back to my house, no.
And I hope they blow your motherfucking ass to smithereens.
You better hope they do, bitch. You better hope they do.
This nigga kidnapped me.
I think I'm entitled. You want answers? I want the truth! You can't handle the truth! What are you, fucking nuts? You thought?
You wet?
Move for time.
Wet?
I'm over time.
Deny. Assistència de Xavi, més capradeta per Messi, Messi, immens Messi, encara 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 Messi, encara